Welcome to the 42nd Annual Ohio Mock Trial State Championship. I would like to welcome our two state finalists, Archbishop Hoban, who will be playing plaintiff today, and Sylvania Southview on defense. Congratulations to our teams. It is a great achievement to make it to the championship round. Without further ado, I will turn it over to the bailiff to open court.
All rise. Hear ye, hear ye. The Cardinal County Court of Common Pleas is now open pursuant to adjournment. All having business before this honorable court, draw near, give attention, and you shall be heard. You may now be seated.
Good morning, teams. Welcome to family and friends and guests to the Ohio Supreme Court. It's an honor for us to be here of your panel of judges today. Just a couple of housekeeping matters. I would just remind everybody at this moment to please put your cell phones on silent, if you would please, so that it doesn't interrupt the proceedings. After the proceedings are completed and the scoring judges will introduce ourselves at the end of the round. So at this time, before we begin the trial, I would just like to read a statement for everyone to listen appropriately. Before we begin the trial, I have a brief message to share with today's participants. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of and others we might not be fully aware of, which is why they are called implicit biases or unconscious biases. As participants in the Ohio Mock Trial program, it is important to resist jumping to conclusions or acting upon personal likes or dislikes. Resist letting biases, prejudice, or other public opinion influence your behavior inside or outside the courtroom. Treat all individuals with respect, regardless of ability, gender, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. With that, I would just introduce myself. I'm Judge Matt McFarland from the United States District Court for the Southern District of Ohio. I sit in Cincinnati. I'll be your presiding judge today. With that, are the teams ready to proceed?
Yes, Your Honor.
Very well. Very well. At this time, would you like to make your opening statements?
Yes, Your Honor.
You may proceed when you're ready. And for the record, we are here in the case of Denver Saidi versus Wyatt Latu, case number 25CV2008. And you may proceed.
Your Honors, before my time begins, I would like to take a moment for my team to introduce themselves. My name is Kate Folk.
Good morning, Your Honors. My name is Rachel Greer, representing the plaintiff.
Good morning, Your Honors. My name is Sophia Burgoyne, and today I'll be portraying Denver Saidi in today's case.
Good morning, Your Honors. My name is Gabrielle Ophoff, and today I will be portraying Theo and Ngoma.
Good morning, Your Honors. My name is Vincenzo Maltempi, and I will be the plaintiff.
Very well, you may proceed.
May it please the court. Our elections are not a joke, and damaging the electoral landscape is nothing to laugh about. This is a case about a veteran's career and reputation being muddied by a reckless and irresponsible student bent on getting revenge. But a preliminary injunction in this case would serve to clear the waters of this election and preserve the reputation of Miss Denver Saidi. Miss Saidi is the principal of Trillium High School and a former U.S. Marine. Now, in the summer of 2024, she decided to run for city council to advocate for her students and to promote safety in the city of Harmony. The evidence will show that Miss Saidi was winning this election through December. Now, that was until January 2nd when the defendant, a student named Wyatt Latu, created and posted an AI-generated deepfake. in retaliation for being suspended from a school dance. Now, this deepfake depicted Miss Saidi at that school dance, slurring her words, bragging about drinking and driving, and evading the police. But here's the thing. Miss Saidi never did any of these things. She never said any of these things. Even so, her career and public image have been sullied, as she is now dragging behind her opponent in the polls. Now, the defendant will attempt to justify this video by calling it a parody, a joke. But defamation is nothing to laugh about. And that's why we're here today. We are seeking a preliminary injunction to remove the defendant's video and prevent it from inflicting any further harm onto Miss Saidi's career and public image. As plaintiffs, we have the burden of proof by clear and convincing evidence to demonstrate that Miss Saidi is entitled to this injunction by balancing the following 4 elements. First, that she will likely succeed on the merits of her claim. Second, that irreparable injury will continue to occur without an injunction. Third, that no third parties will be unjustifiably harmed by an injunction. And fourth, that this injunction would serve the public good. To testify on these 4 elements, we will be calling 2 witnesses. First, you will hear from Miss Denver Saidi herself, who will talk about the events leading up to the video and its explosive aftermath. She will demonstrate that the video was indeed defamatory, as she never did any of the things that it alleges. Second, you will hear from Miss Theo Ngoma, one of the most prominent campaign managers in the state, who will break down Miss Saidi's polling data and her initial lead. She will reveal that the video has already caused Miss Saidi to lose this initial lead and will cause her to lose the election if it is allowed to persist. Your Honors, the court has held that it is always in the public interest to prevent the violation of a party's constitutional rights. Now, that includes Miss Saidi's right to be protected from defamatory statements. You cannot yell fire in a movie theater, you cannot shout bomb at the airport, and you cannot post defamatory statements to derail an otherwise fair election. A ruling in favor of the plaintiff sets a powerful precedent, protecting our electoral system from damage under the guise of a joke. Therefore, at the conclusion of this hearing, my co-counsel, Ms. Rachel Greer, will ask you to rule in favor of Ms. Saidi and grant the injunction. We cannot allow this deepfake to further turn our elections into a joke. Thank you.
Very well. Thank you, Ms. Folk. Is counsel ready to proceed with your opening statement?
Yes, sir.
You may proceed.
Your Honors, before I do proceed, may my team introduce themselves.
You may.
Good morning. My name is Naomi Bell, counsel for the defendant, Wyatt Latu. Today, I will be providing the opening statements, the direct examination of Ms. Emery Popovic, and the cross-examination of Ms. Theo Ngoma. And my co-counsel.
Good morning, Your Honor. My name is David Liu, counsel for the defendant, Wyatt Latu. Today, I will be conducting the direct examination of Mr. Wyatt Latu, the cross-examination of Denver Saidi, and providing today's closing arguments for the defense. Our witnesses.
Good morning once again, Your Honors. My name is Justin Lee, and today I'll be portraying the role of Wyatt Latu.
Good morning, Your Honors. My name is Theo Yermal, and I will be Emery Popovic today. And our timekeeper.
Good morning, Your Honors. My name is Jesse Long, timekeeper for the defense.
May I proceed?
You may.
Your Honor, opposing counsel, may it please the court. The plaintiff came up here and told you elections are not a joke, but we beg to differ. Saturday Night Live, Mad Magazine, political cartoons. All of these things have humor that not everyone's going to find funny. But the fact of the matter is, the Sixth Circuit Court in Novak held that the prerogative of American citizenship is the right to criticize public officials. And this includes not only informed and responsible criticism, but the freedom to do so foolishly and without moderation. Today's case involves such circumstances when on January 2nd of 2025, the defendant, Wyatt Latu published a parody. A parody that poked, prodded, and even teased his principal, Miss Saidi. But as the evidence will show, upset with that teasing, Saidi now seeks to suppress Latu's freedom of speech. Consequently, in today's preliminary injunction proceeding, the plaintiff will fail on their motion for an injunctive relief for 2 reasons. The first being, based on the totality of the circumstances, any reasonable viewer would not have viewed it to be defamatory, but a parody, which is protected under our First Amendment. And the second reason is that, the plaintiff has the burden of clear and convincing evidence, but they will not be able to meet that burden when it comes to the issue of irreparable harm. So let's look at that first issue. Was this video a parody? Well, in order to answer that question, we must look to the courts and Corso Ventures, FARA, as well as their own expert, Emery Popovic, who will explain to you that you must look at the video from the perspective of a reasonable viewer and how they would perceive the visuals, the statements made, and the context of the video. And what you'll learn here today is that when it came to the visual distortions, that video was filled with them. From Miss Saidi's hair floating off her head to on her head, to her lips not matching what she was saying, and to her fingers bending at inhuman angles. And when it comes to the statements made, although the plaintiff claims she never did any of these things, she never said any of these things, the fact of the matter is, Your Honor, Mr. Latu didn't come up with these jokes. It was all from Saidi. Because it was Miss Saidi who mentioned her political campaign at a school event. It was Miss Saidi who mispronounced the Snow King's name. And it was Saidi who mentioned Rossi's, a local bar, in front of her high school students as an excuse for that mistake. All Mr. Latu did was embellish these mistakes. And how? By adding ridiculous statements about her being a big popular kid, by adding crazy movements like finger guns and winking, and by using Saidi's own statements as a source for these jokes. All things that would have led any reasonable viewer to conclude this was a parody. When it comes to the issue of irreparable harm, the plaintiff will not be able to carry their burden because the fact of the matter is they had the opportunity to take this video down by simply paying cash. And you know what Theo Ngoma did? She did nothing. And as Cheetah Minor held, monetary damages do not constitute irreparable harm. At the end of the day, Your Honors, we agree with the plaintiff. Granting this injunctive relief would set a powerful precedent, but also a dangerous one. It's why that at the close of today's trial, my co-counsel David Liu will request that you deny the request for injunctive relief. Thank you.
Very well then. At this moment in time, I'd ask the bailiff to swear all the witnesses in jointly.
Yes, Your Honor. Will all people who are to give testimonies in today's hearing please step to the front of the room? Raise your right hand. Do you swear that all testimonies you are about to give today will comply with the rules and regulations of this Ohio mock trial competition?
I do.
You may now be seated.
Thank you, bailiff. Well done. Are the parties ready to proceed with their case in chief from the plaintiff's perspective?
Yes, Your Honor.
Very well. You may call your first witness when you're ready.
The plaintiff calls Miss Saidi.
Miss Folk, you may inquire when you're ready.
Good morning. Please state and spell your name for the court.
My name is Denver Saidi, and Saidi is spelled S-A-I-D-I.
Well, Miss Saidi, just tell me a little bit about yourself.
Well, I went into the Marine Corps straight out of high school, Semper Fi, and then I used my GI Bill to earn my degree.
Well, what is your educational background?
Well, I graduated from Miami University with a Bachelor's of Science in Education, And then I went on to earn my master's degree from the Buckeye State University.
So, what are you currently doing for a living?
Well, I'm currently the principal of Trillium High School, but, I've just recently taken my shot at politics, so everyone, please, make Harmony a happier place for the people that live there and vote for me, Denver Saidi, in the upcoming election for Harmony City Council.
You mentioned your campaign for Harmony City Council. What exactly has that campaign entailed?
Well, Miss Folk, I've put a lot of time and effort into my campaign, with posters and flyers and drafting campaign speeches. But my favorite thing about campaigning is this thing called knock and talks, where I'll go door to door and ask the voters' opinions. Because at the end of the day, it all comes down to the people. Plus, if any of you know Theo and Ngoma, she's obsessed with the polling data. So that plays a pretty big part in it too.
Well, hold on. You mentioned Theo and Ngoma. Who is Miss Ngoma?
Sorry, Theo is my campaign manager.
Miss Saidi, what brings you here today?
It actually has to do with the upcoming election. Not too long ago, a kid named Wyatt Latu pulled a pretty big stunt that's really affected me and my campaign.
Objection, Your Honor. As to speculation, may I be heard?
You may.
Your Honor, at this point in time, the witness has laid no foundation as to the effect of this stunt performed by Mr. Latu as a result of the effect on their campaign. And as a result, we'd ask for that foundation either be laid or this witness not speculate as to the possible effect that this stunt would have had on their campaign.
May I respond?
Of course.
Your Honor, a witness may offer an opinion or insight based on her perspective. That is simply what Miss Saidi is doing. And in addition, this question is laying foundation as to how her campaign was affected, which we will get into later during this direct examination.
May I respond?
You may.
Your Honor, at this point in time, I believe this witness has said that this stunt has affected her and her campaign. This is not laying foundation for anything. Rather, it is making a claim that this impact has already occurred and is continuing to occur. We ask that this foundation be laid because we don't know what stunt this is. We don't know what it involved. We don't know how it directly impacted her campaign. And we ask that she not speculate on that fact.
Very well. It's a good objection. Both sides have well argued. I'm going to sustain it in part. You might just ask some background questions before you ask the question you've asked just now.
Well, Miss Saidi, what exactly was that stunt?
Well, Wyatt created an AI deepfake video of me saying some pretty terrible things. Things I would never even begin to dream of saying.
Well, let's just take one step back. Who exactly is Wyatt Latu?
Well, Wyatt's a senior at Trillium, and I'm the principal. And as the principal, I like to take the time to get to know all of my students, even the troublemakers. But at first, Wyatt seemed like a model student.
As to improper character attack with the word troublemaker.
Response?
Your Honor, firstly, this evidence is not being used to show character or to paint Mr. Latu in a bad light. Instead, it is being used to show bias. This was a student that was punished by a teacher that had disciplinary infractions, and bias is always relevant under Evidence Rule 616A.
May I be heard?
Of course.
Your Honor, according to Rule 404, improper character attack is related to when a witness provides testimony about another person's character with showing that they have the propensity to act in a certain way in the future. With the word troublemaker, it implies that Wyatt Latu has conducted bad behavior in the past and as a result does the same exact today, and therefore that would go towards this witness's character and the truthfulness.
May I respond?
It's unnecessary, but you did a good job. At this point, I'm going to overrule the objection. I'm going to give you a lot of latitude on cross-examination to inquire about this topic.
Yes, Your Honor.
Miss Saidi, who is Wyatt Latu?
Wyatt, again, is a senior at Trillium. And when I first became acquainted with him, I had no complaints. They seemed like a pretty model student. He's even on the mathletes team. Until it's like their whole personality just changed.
Well, what seemed to change about Mr. Latu?
Well, one day he was this kind-hearted kid, and the next he was interrupting classes and making fun of other students, and he even got caught with a vape on a school bus. I mean, who does that on a school bus?
So you mentioned this incident with a vape being used on the school bus. Did you address this?
Of course, yes. When I first found out about the incident with Winston, Wyatt. When I found out about the incident with Wyatt, I suspended him from the snowball, which I felt bad about. I don't like disciplining kids, but my only other option was a week-long suspension during finals. I thought I was doing the kid a favor.
So you suspended Wyatt Latu from the snowball. What is the snowball?
The snowball is this annual school dance that the students just absolutely love. And I usually like to show up and I'll give a little speech. Although I can't say the students cared for this one all that much because I'm always messing up people's names. I can't help it. There's so many of them. But I really didn't think anything of it until after the winter break, that is.
Well, what happened after the winter break?
I got this panicked call from my mom about some video. I just assumed she was talking about the snowball, which is always live streamed and posted online, and I reassured her that name mistakes happen and there was really nothing to worry about.
Was your mother referring to the live stream?
No, she was not. She was referring to the AI video that I mentioned earlier.
Objection, Your Honor, as to hearsay to the mother's statements.
May I respond?
You may.
Your Honor, this evidence is not hearsay, as hearsay is an out-of-court statement being offered for the truth of the matter asserted. We are not offering this for the truth of the matter asserted, but instead to show effect on the listener and establish what Miss Saidi did next and what she thought next.
May I be heard?
You may.
Your Honor, firstly, we believe that this line of testimony is being used to show the truth as to the mother's mindset, and therefore that would rely on speculation by this witness, which would be outside their scope. But even if opposing counsel were to be offering this evidence as not for the truth, we then therefore don't believe that it's necessary to include in their testimony today.
Good objections. Well argued. I'm going to overrule the objection. It may be part of the res gestae. You can look that up afterwards if you're not sure what that is, but you may continue to inquire.
Yes, Your Honor.
Which video was your mother referring to?
The AI deepfake video.
Did you hear anything else about this video in the days that followed?
I did, actually. About a day later, I got another panicked call from my campaign manager, Theo and Ngoma, and she emailed it to me and told me to watch it immediately.
Did you watch it?
I did, yes.
And what did you see when you watched this video?
Well, I saw me at the dance giving my speech, except it wasn't me, if that makes any sense. I mean, it looked like me, about the same height, same clothes, but something about it was just off. The things I was saying, my demeanor, my whole personality was terribly wrong, and it turned out to be the AI video of me slurring my words and acting drunk and being completely ridiculous.
Your Honor, at this time, I would like to introduce what has been previously marked and stipulated to as Exhibits A and B.
You may, and they have been provided to us. You may inquire.
I would like to draw the court's attention to the fact that in that binder there is a clean and unmarked copy of both Exhibit A and B for the witness to review. Ms. Saidi, are you familiar with these documents?
I am, yes.
What are they?
Well, Exhibit A is the transcript of the speech that I did give at the Snowball, and Exhibit B is the transcript of the speech that I did not give at the Snowball.
And how are you familiar with these two speeches?
Well, I gave one, and I listened to the other on the video.
Ms. Saidi, just walk me through some of the differences between the speech you gave and the speech that you listened to.
Sure. Well, in my speech, I start by saying how much Trillium means to me, and how the school and the students it's what's inspired me to run for city council. And then I announce the names of the king and queen of the dance. Now, in the fake speech, the fake version of me talks about how this dance is just some fake popularity contest, and how that's all that Harmony City Council means to me.
Are there any other differences between the real and the fake video?
There's quite a few, but the worst part of it all is that the fake video makes it look like I was drunk driving and evading the police by saying, "Thankfully, Harmony police don't drive like they used to. They clean lost me on the way up here from the bar."
Well, Miss Saidi, let's just be 100% clear. Did you do any of the things that this fake video alleges?
No, I never did or said any of these things. I mean, one of the main platforms of my campaign is anti-drunk driving. There's no way I'd actually go and do it.
Thank you. You can set those exhibits aside. Ms. Saidi, to your knowledge, how has this affected your campaign?
I mean, you tell me, Miss Folk. Before the video, I'm winning, and now after it, I'm losing. And I went door to door and conducted a knock and talk, and 66% of the polling data suggested that...
Objection, Your Honor, as to hearsay.
May I respond?
Of course.
Your Honor, this evidence is not hearsay under 803E, records of regularly conducted activity. Ms. Saidi is referring to polling data, which is a data compilation that was gathered at the time the poll was conducted. Furthermore, under 803F, statements being used to show character and reputation within the community are not considered hearsay.
May I be heard?
You may.
Your Honor, this witness is relying on information found in Exhibit F in today's case. Firstly, with their basis of 803E, this exhibit, or rather, the information that this witness is relying upon is the knock and talks that she did while she knocked on the doors of homes and people in Harmony. She has not provided any sorts of regularly conducted business records or polling data as to what those show, rather her own out-of-court statements from the individual she talked to. Furthermore, as for 803F, their argument against reputational damage, it's clear that in this case, they haven't laid the foundation as to whether or not this reputation shows the before and the after. They claim that they know the after, however, we've not heard any information as to whether these knock and talks mimic the before, meaning that that reputational damage only serves to show the impact after, which would be showing truthfulness or trying to prove a truth for the matter asserted, Your Honor.
Very well. Again, very well argued. I'm going to overrule the objection. And going forward, counsel, as to the objections, what I intend to do is to give the person objecting an opportunity to lay their reasons, the opposing side, and then I'll come back to the original person making the objection. You don't need to ask me to respond, so well done.
Yes, Your Honor.
You may continue, and counsel, you may inquire vigorously on cross-examination as to these statistics.
Yes, Your Honor.
Well, Ms. Saidi, you were talking about the knock and talk that you conducted. Can you just finish up on that?
Right, yes. After I conducted the knock and talk, 66% of the polling data suggested that the public opinion of me had just recently changed, for the worse.
Well, to your knowledge, could anything else have affected your polling numbers?
I mean, there was an event at the senior center that I planned on going to, but in the end I decided not to. But, you know, it was nothing personal, just politics, which, again, I'm still pretty new at. So I can see how that might have upset a few people, but even then, the event was pretty small. Maybe only 100 people were there.
So, Ms. Saidi, overall, what was the net result of your polling?
Again, before the video, I'm winning, and now after it, I'm losing. It's really looking like this whole video thing is going to completely destroy my chances of winning for city council if it isn't taken down. And I can't believe my political career is over before it even started because of some fake video that, frankly, just isn't even that funny.
Thank you, Your Honors. No further questions.
Very well, then. Counsel, you may inquire on cross-examination when you're ready.
Yes, Your Honor. May I begin? Now, Ms. Saidi, I want to first start by talking about something you mentioned on direct examination. In fact, I did write it down. You said that in the Latu video, there were statements that things you would never say, correct?
That is correct, yes.
Now, I'd like to take a moment to examine that video. Could you first flip to Exhibits A and B?
Sure thing.
Now, starting with the visuals of the video, you did end up watching the video created by Wyatt Latu, didn't you?
Yes, that's correct.
And you noticed that your movements weren't exactly normal, right?
That's true.
In fact, your hair at certain points of the video was displaced.
That is true, but the main thing that stood out to me were the things that I was saying, like making jokes about drunk driving and evading the police, which I never did.
But directing you back to my question, those were visual inconsistencies that you noticed. Isn't that correct?
That's correct, yes.
Even more so, your fingers were even bending at awkward angles, correct?
That's true. I actually did a weird finger gun motion, which honestly, it was awkward just doing it now. I would have never done that.
Sure. Now I want to talk about the content of the video. Now, in Wyatt Latu's video, it has you talking about your campaign, saying you're a big popular kid, correct?
Yes. Yes, it does.
But to be clear, you're still the principal of Trillium High School, and you're running for city council, aren't you?
That is true. Yes.
And in your original speech, you were actually the first person to bring up your city council campaign. Isn't that correct?
I did bring it up. Yes, like I said, I was talking about how the school and the students is what's inspired me to run for city council.
And you made that reference to your campaign at a school event before Wyatt Latu ever published his video, correct?
That is true. Yes, it was before the video was published.
Furthermore, you also made a mispronunciation of the name in your original speech, didn't you?
I did, unfortunately, mispronounce Daniel Jenkins' name as Danielle, and it's honestly not the first time it's happened. I really feel bad for the kid, I do.
Even though you said in your direct examination that these were things you'd never say, you made that mistake before, and you made it in the Latu video, didn't you?
That mistake, that's correct. But again, the drunk driving joke, evading the police, I never said or did any of those things.
So I'd like to talk about that for a moment. Now, in Wyatt Latu's video, it has you saying that you were kicking it back with old Melnick at Rossi's, a bar, doesn't it?
It does, yes.
But you were actually the first person to bring up a bar in your original speech. Isn't that correct?
Well, like we've said, Mr. Liu, I unfortunately mispronounced Daniel's name, and I was trying to make light of a situation. I cracked a joke, but I realized it wasn't the time or the place to make a joke like that.
To be specific, you cracked a joke about a bar, Rossi's, didn't you?
That is true, yes.
A joke about a bar in front of your student body, correct?
Yes,
It's safe to say that most of them are underage, correct?
they are.
And after that, you took this joke about a bar, and it was live streamed, wasn't it?
It was, yes. Like I said, the snowball is always live streamed and posted online.
You posted this joke, this poorly timed joke about a bar, to your social medias, didn't you?
Well, it was after the fact that Wyatt's video went viral with all of the misinformation, and I was hoping to combat some of the false information that was spread by posting the true video.
So that's a yes to my question. You posted that joke for the public to see.
I did, yes.
Now, I want to talk about what you did after you learned about the Latu video. As you mentioned in direct examination, you went door to door knocking on people's homes, correct?
I conducted a knock and talk. Yes, that's true.
Now, you left out your questions in direct examination because the thing you asked these people were, has your opinion of me changed, correct?
Yes.
But let's be very clear, Miss Saidi. You never once asked any of those homes, did you see the Latu video? Isn't that correct?
I did not, no. However, the knock and talk was conducted after the video had gone viral.
So even though it was done after the Latu video and you were worried about it, you never asked a single home if they had seen it. Is that what you're telling us?
No, I did not.
You never asked a single home, did the Latu video change your opinion of me, Principal Saidi?
No, I simply asked if their opinions had changed.
The fact of the matter is, when it comes to that 66%, you never asked the question, why? Isn't that correct?
That's true.
Now, lastly, I want to take a look at the timing of all of these events. If you could please flip to what's been previously marked as Exhibit F.
There's quite a few exhibits in this binder.
Yes, certainly.
There it is.
Now, I want to focus on the last page, being the polls. Those two polls are from January 1st to January 7th, aren't they?
That's correct. Yes.
I want to take it and splice it by age groups. Now, in the under 30 age category, there is no change in the support for you, correct?
That is correct. Yes.
In the 35 to 50 age category, there is absolutely no change. Isn't that correct?
That's also correct. Yes.
But when we move on to the 50 to 65 age category, that's where we see people losing support for you, correct?
Yes.
And that same trend is consistent in the over 65 age category. Isn't that right?
Yes.
Now, you claimed that this was because of the Latu video, but there was a senior center fireside chat party on January 1st, wasn't there?
There was. Yes.
an event that you skipped out on, correct?
I did choose not to attend that event. I chose to spend my time at the 30 Under 30 Gala. I thought I could reach a larger part of the population that way.
In fact, one of the reasons why you decided to miss out, in your own words, because it was a waste of time.
I did think my time would be better spent at the 30 Under 30 Gala. That's true.
And your opponents, they went to that event, didn't they?
I believe so, but if you put it that way, Mr. Liu, I'm the only candidate that went to the 30 Under 30 Gala.
You were the only candidate to miss the Senior Center chat. And you were the only candidate in that poll to lose support in the older generation of Harmony. Isn't that correct?
That's true, yes.
And nowhere in that newspaper does it ever mention a Wyatt Latu video. Isn't that correct?
It does not, no.
But what it does mention is the possibility of you snubbing the senior citizens. Isn't that
Objection,
correct?
Your Honor. Attorney testifying is yet to pose a question to my witness.
May I respond?
You may.
Your Honor, my question is directly related to asking her whether or not that statement is in that newspaper, which it is an exact statement, Your Honor.
Any response?
Your Honor, opposing counsel simply said that this document was based on Ms. Saidi snubbing a senior center event. Not only is that argumentative, there is nothing here, no question in that statement.
May I respond?
It's unnecessary at this point. I'm going to sustain the objection. You might want to rephrase your question.
Yes, Your Honor. But the fact of the matter is, in that newspaper poll, it references the possibility of you snubbing the senior centers. Isn't that correct?
It does say that, yes.
Thank you. I have no further questions.
Redirect for this witness?
Briefly, Your Honor.
You may inquire when you're ready.
May I first see how much time we have remaining
Of course.
for direct examinations?
You have 11 minutes left.
Thank you.
May I proceed?
You may.
Ms. Saidi, on cross-examination, you were asked about attending Rossi's. Why do you attend Rossi's?
Well, Rossi's is a really great spot for community functions, and it's actually one of my campaign spots, so I attend Rossi's frequently.
Thank you, Your Honor. No further questions.
Thank you. Recross. You may inquire when you're ready.
No, Your Honor. No recross necessary.
Very well. Is this witness excused at this time?
Yes, Your Honor.
Very well. You're excused.
Thank you.
You may call your next witness when you're ready and inquire as such.
Your Honor, the plaintiff calls Miss Theo and Ngoma to the stand. May I proceed?
You may.
Good morning. Please state and spell your name for the court.
My name is Theo Ngoma. Ngoma spelled Ngoma.
Miss Ngoma, how are you involved with today's case?
I'm Denver Saidi's campaign manager. And believe me, she's lucky to have the best in the state.
Well, what qualifies you for this title as best in the state?
It's a title I've more than earned, Miss Greer. Elkin Lewis, Evan Eric, Pastor Robin Peace. Those are all some of the many campaigns I've worked on, and I've gotten people in office in all three branches of the government, from Justice Jordan Gutenberg to Senator Alex Leslie.
Now, how did you get into politics?
Well, I come from a huge political family. My sister Cheryl is actually a county commissioner, so politics was always a topic on the dinner table. It made for some pretty interesting Thanksgivings. But surrounded by so many big names, I figured I had to make a name for myself.
So why did you choose campaigning rather than running yourself?
Why bother being king when you can be the kingmaker? I figured people probably wouldn't vote for me if I ran for office, but I actually got a bachelor's in political science at Miami University and a master's in campaign management and elections from the Buckeye State University, so I thought that I could help get other people into office. So after publishing my master's thesis, I began practical training in campaign management.
And what did that practical training and campaigning entail?
Well, I got to work under some of the best campaign managers around. Starting from the bottom and working my way to the top, I ran multiple different positions in a campaign and eventually ended up managing campaigns of my own.
Now, can you explain what you do as a campaign manager?
Being a campaign manager means managing a lot of the logistics, everything from what events your candidate goes to, the speeches they make, and other important details. And as I worked in campaigns and developed my career, I developed my specialty, reading polls.
Can you explain to the court how polls work?
Of course. Polls are absolutely critical to a campaign. It lets you know your candidate's chances of winning the closer you get to the election. It also shows your candidate's standings with different demographics, such as age, gender, street, profession. So poll analysts like me will target different demographics depending on what's most important to a campaign. We'll slice up these polls and both conduct our own knock and talks, but I also really like to analyze the polling polls, which is the national polling company in the country.
Your Honor, at this time, pursuant to Evidence Rule 702, I move to admit Ms. Ngoma as an expert in campaign management and poll analysis based on her specialized education, training, and experience.
Very well. Any objection?
No objections, Your Honor, but I thought it was the court's understanding that tendering would not be necessary.
It's correct, but I will declare her as an expert at this time. You may inquire. Thank you,
Yes, Your
counsel.
Honor,
Oh, go ahead.
Could the defense reserve the right to object to any testimony that strays outside the scope of her expertise?
Of course, you can object to anything you like.
Thank you, Your Honor.
Very well. You may proceed.
Moving to the specifics of your campaign with Ms. Saidi, how did you first get involved?
Well, I've known Denver for years. We go to the same church, actually, so I've gotten to know her character pretty well. And she approached me one day after Mass to ask if I would be her campaign manager. I have to admit, I did hesitate a bit before I accepted because I usually work on much higher level statewide campaigns. But Denver, she just talked so passionately about her kids at Trillium, and you could tell she really cared about her political platform, education reform and anti-drunk driving. So her passion and my love of small towns won me over.
So after agreeing to get involved with Ms. Saidi's campaign, what was the start of the campaign like?
The campaign started out wonderfully. I organized a campaign apparatus with a policy team, messaging team, finance team. I crafted some TV ads and some really great attack ads. Denver started showing up to rallies and giving speeches, and donations were just rolling in by the time we had our first poll.
What were the results of that first poll?
Well, the first poll was a tie.
Did this change?
It certainly did, Miss Greer. By December 1st, Denver had grown to a 4-point lead, and later in December, we'd grown that to a 6.
Objection,
Now,
Your Honor, as to lack of foundation. May I be heard?
You may.
The witness has not laid adequate foundation as to who exactly conducted the polls. As earlier during their direct examination, they mentioned they also rely on outside polls, such as the ballot polls. So we would ask that that foundation be laid.
May I respond?
You may.
Your Honor, under Evidence Rule 702, she has been admitted as an expert in campaign management and poll analysis. Secondly, under 702.2, an expert opinion may give their expert testimony if it is based upon reliable scientific or specialized knowledge. She has already testified that Poolag is a nationally reputable polling company. Therefore, it would be rational that she relies on these polls as part of her scientific data.
Any response?
Yes, Your Honor. First off, the original objection was to the fact that she didn't reference where these polls came from and therefore lack of foundation. But to opposing counsel's point that she was relying on the Poolag polls, the fact of the matter is in Rule 703, it states that in order for an expert to testify, they must rely on what they personally perceived or what was admitted into evidence. And at this time, there has not been any Poolag polls admitted into evidence. And she is not a member of Poolag. She cannot verify what the protocols were when the Poolag polls were conducted, and therefore we would ask that more foundation be laid.
Well argued, well placed. I'm going to overrule the objection. Again, I'll give you the same latitude on cross-examination. You can inquire as much as you like.
Yes, Your
You
Honor.
may continue.
So you testified the campaign was going well. Did this momentum continue?
Unfortunately, it didn't. All because of January 3rd, 2025.
What happened that day?
That's the day I found out about a certain tactic video made by Wyatt Latu. As soon as I saw the video, my heart sank. Thought it was Denver at first, honestly. But after I contacted Denver, she assured me that it wasn't actually her. But I could tell this was bad. A fake video that looked real and made it seem like she said things that she never did. It was probably one of the worst campaign crises I've ever seen.
So, upon discovering this video, what did you do next?
I did some digging. I went to the platform where the video had been originally posted and found an email address linked. So I contacted the poster, Wyatt Latu, and very politely asked him if he would take it down, explaining that it was defamatory and was going to harm a good person's reputation.
And how did Wyatt respond to this?
With blackmail. He had the audacity to try and strong-arm me and wanted me to pay him
Objection,
to
Your
take
Honor,
the video
as
down.
to improper legal opinion.
May I respond?
You may.
Your Honor, Ms. Ngoma has been admitted as an expert in campaign management. Given her expertise with politics, she would understand what blackmail is, as this is rationally based on her perception. Next, this is highly probative information as it goes to the first issue in today's case, that irreparable harm, or likelihood of success on irreparable harm. This is going to show the malice of Wyatt Latu. This is Ms. Ngoma's own interaction with Wyatt. She's aware of what went on.
May I respond to
You
that,
can.
Your Honor? We would actually disagree, and we would say that under Rule 403, this is more prejudicial than probative, because the fact of the matter is there has been no criminal activity, and this is not a criminal trial. This is an injunctive relief trial, and we believe that it confuses the issues in today's hearing.
May I respond?
It's unnecessary. You're winning. I'm going to overrule the objection. Again, you can inquire about the use of blackmail if she intended it or if there is a criminal investigation to boot.
Yes, Your Honor.
Very well argued, though.
So after Wyatt refused to take the video down and offered you money for it, what happened next?
Well, I did not pay him. I'm no stranger to threats like this, and nor am I a fan of the people who make them. So I told Wyatt, I will do nothing for you, and I will pay nothing to you. And once again, very politely asked him if he would take the video down. And then he tried to claim he was an artist who didn't have to listen to the whims of a politician. I knew modern art was declining recently, but wow.
So upon this video staying online, how was the campaign and the days that followed?
The fallout was immediate and terrible. We ran 3 polls in the next 5 days and found that our December lead had completely vanished. Furthermore, Denver standing with the elderly had cratered. For the elderly votes, that's the demographic I paid the closest attention to during this election, as Denver's opponent, Ophik, had a lock in that category for years. But before this video came out, it turns out that Pollig clocked Denver as pulling ahead in that category with a 61% majority. But after this video came out, Denver standing with the elderly cratered.
I would now like to reference the clean and unmarked copy of Exhibit F to the left of Ms. Ngoma. Please flip to Exhibit F, Ms. Ngoma. Now, can you please explain the graphs on the top of the page?
Of course, Ms. Greer. If you look at the graphs on the top of the page, these are some of the polls put out by Pollig, the polling company I mentioned earlier. The first one comes from January 1st. Now, if you look along the bottom, you can see the different age group categories on the x-axis, and on the y-axis, you can see the current percentages and majorities they have in that category. In the first graphs, you can see that in both the 50 to 65 and the over 65 categories, Denver Saidi has a lead in this demographic over her opponent, Ophik. Additionally, in the over 65 category, there is a 10% undecided.
Now, can you explain the graphs on the bottom of the page?
If you look at the graphs on the bottom of the page, you can see this one came out on January 7th, which is after the video was posted. And you can see that Denver has lost her lead in both the 50 to 65 and the over 65 categories. Additionally, the 10% undecided has gone down to a 3%, and Ophik has gained supporters.
That'll be all for that exhibit, thank you. Ms. Ngoma, do you have an opinion to a reasonable degree of poll analytics and campaign management certainty as to what could have caused this drop in the polls?
I do.
And what is that opinion?
A drop in the polls this drastic can only be caused by a profound external factor, and that factor is Wyatt's video.
What is the basis for this opinion?
The basis for my opinion is my knowledge of how statistics and poll analysis works, and the fact that a drop in the polls of this margin can only be caused by certain events with a wide audience and reach, such as Wyatt's video. There is no other events that would have had an impact this substantial.
So, could anything else have caused this change?
Some people could try to say that the drop in the polls was caused by Denver's absence at a senior center event. But that event had a limited audience of only 100 people, which is not enough to sway a poll like this. No, Wyatt's video is the thing that has altered the electoral landscape.
How was this video able to alter the electoral landscape?
I want to be clear. Wyatt's video is a threat to democracy everywhere. It has fed the voters lies about Denver's Saidi, obscuring the waters of truth. If defamatory videos like this are allowed to continue, then any guy in his mom's basement could manufacture a video of someone saying or doing anything. It's confusing the voters, lying to them, and overall threatening this election and democracy across the country.
Thank you, Ms. Ngoma. No further questions.
Cross-examination, counsel?
Yes, Your Honor.
You may inquire when you're ready.
Thank you.
You're welcome.
Good morning, Ms. Ngoma. I'd like to ask you a few questions. First, I want to talk to you about your relationship with Miss Saidi. Now, earlier during direct examination, you mentioned that you've known her for years, right?
That's correct. We attend the same church.
And as you mentioned, it was actually at this church that Miss Saidi approached you asking if you could be her consultant, right?
That's correct. Consultant and campaign manager.
And as you said, you were a bit hesitant at first, but ultimately you agreed, right?
That's right.
But, Miss Ngoma, you actually left something out. You told Miss Saidi, I'll do it for you, your friend, right?
That's right. Since Denver, I could see she was so passionate about her election, I decided that I would in fact take on her case. And she's a friend of mine, so I knew that she was of good character, and I could tell that she really did care about this election.
Right, and not only did you tell her that, you actually gave her a 25% friends discount, didn't you?
I did, Miss Bell. A smaller election like this, city council instead of statewide, it doesn't require as many funds to run, so I could afford to give her a discount.
Right, and you, even with this discount, were being paid $5,000 a month, right?
That's right, as not only is this my job, but even if it costs less, it still does cost money to run a campaign.
And even as you sit there, testifying, you're still on Miss Saidi's payroll as her consultant. Yes?
Well, as the election has not taken place yet, I am still being paid for managing it.
Now, I want to move on and talk to you about the Latu video. I actually wrote this down. You said, quote, "When I learned of this video, my heart sank." Did I get that right?
That's correct. I thought it was the real Denver at first, and so I thought that our campaign was absolutely ruined. But even after I learned it wasn't the real Denver, my nerves still wouldn't settle because I could tell the voters were going to be just as confused as I was, and this could ruin our campaign if it's not taken down.
Right, you said your nerves weren't settled. So following learning of this video, as you mentioned earlier during direct, you reached out to the creator, Wyatt Latu, right?
That's correct.
You asked him to take it down?
I did.
And while you said he blackmailed you, the fact of the matter is, he said, "What can you do for me? I'll sell you the rights to the video."
That's right. He wanted me to pay him to take down the video defaming my client, who, by the way, is his principal. A high school student wanted me to pay him to stop lying about his principal.
So going back to my original question, he simply asked you if you wanted to buy the rights to the video.
That's correct.
And you say he blackmailed you, but Miss Ngoma, he did create this video, didn't he?
He did, Miss Bell.
He's the one who put the prompt into the AI generator?
That's right, and he's the one who posted it online to cause such a ripple effect in my campaign.
Right, he posted online to his account.
That's correct.
Miss Ngoma, you didn't post this video, did you?
Of course not.
Objection, relevance. Under Evidence Rule 401, relevant evidence makes an issue more or less probable. Whether or not Miss Ngoma posted this video is not relevant.
Might be here.
Of course.
Earlier during direct examination, Miss Ngoma testified that Mr. Latu blackmailed her. I'm simply inquiring about her reasoning for saying that Mr. Latu blackmailed her.
May I respond?
You may.
If we want to address the blackmail, that is okay. However, there is no question today about whether or not Ms. Ngoma posted the video. It is a clear fact of this case that Wyatt Latu posted the video. Therefore, I ask that we move on from this line of questioning.
Excellent argument, ladies. Very well done. I'm going to sustain it in part as it pertains to the relevancy of her posting the video, because that's really not relevant, but I'm going to allow you complete latitude about the blackmail inquiry.
Yes, Your Honor. Now, Ms. Ngoma, the fact of the matter is, this was Latu's video on Latu's personal account, correct?
Yes, as I've said.
Now, moving on. Earlier during direct examination, in response to Latu offering you to pay for the rights to the video, you said, "I will do nothing and pay you nothing." Right?
Of course, it would set a terrible precedent if I allowed videos like this to go, and if I just paid people to take down content that was defaming my clients.
Well, Ms. Ngoma, you just said, at the time, it was cash for Latu's video, right?
Yes, a terrible precedent.
And you didn't do it.
Of course not.
Now, I want to move on and talk to you about the polls. Earlier, you mentioned that following the Latu video, you were worried about the campaign, of course, right?
Of course, as you can see, as I mentioned earlier, the numbers are dropping in the polling polls, and we won't be able to recover this lead if the video isn't taken down.
So you conducted a series of polls from January 3rd through the 8th, right?
That's correct. We performed some knock and talks, but also Pollig put out their polls.
Well, let's first talk about your polls. You conducted 3 polls between January 3rd and the 8th.
That's correct.
And these had a similar sample size and margin of error of the ones you conducted previously, right?
Correct again.
Now, earlier during direct, you said that it's important to slice and dice polling to reflect the issues that voters care about, right?
That's right, which is why I was paying such close attention to the elderly demographic.
Right, you can also ask questions about why voters might vote for your candidate.
That's correct.
And why they might not vote for your candidate.
Yes.
Now, let's first talk about your polls. On direct examination, you said that you cratered in the polls, right?
We did. After the video came out, not only did we lose our 6-point December lead, but you can, as I mentioned earlier, you also see the percentage points dropping in the elderly categories in Pollig's polls.
Now, to be clear, in these polls, you never asked voters if they saw the Latu video, did you?
Well, the purpose of the Pollig polls is to ask who's voting in the election. Polls give you statistics about what people are doing, not the whys or motivations behind them. So why people are voting the way they are is something you gather from the circumstantial evidence surrounding the polls. Statistics give you the facts, and the circumstances give you the reason.
Ms. Ngoma, is it your testimony today that polls can't give you information about why voters vote a certain way?
Well, they can give you that information, but with these Pollig polls, for example, it's the circumstantial evidence that I've figured out it's the video that caused the problem.
Right, and even with your polls, you use circumstantial evidence to establish it was the Latu video who created your polls, right?
That's correct. Circumstantial evidence is what you use in situations like this.
Circumstantial evidence is what you use in situations where your polls crater?
That's correct.
Circumstantial evidence is what you use when there's a profound external factor that...
Objection. Relevance. May I be heard?
You may.
Your Honor, courts have ruled that circumstantial evidence and hard evidence have the same value, especially in a case like this, which is very case-specific. Secondly, under Evidence Rule 705, an expert witness may disclose their opinion if it is based upon reliable methodology and facts. Ms. Ngoma is well within her expertise to testify as to her inferences drawn from the data, which under 705 she has done.
May I respond to that, Your
Of
Honor?
course.
Your Honor, I'm simply asking Ms. Ngoma about her basis of her final conclusion today. And I'm also curious to see where opposing counsel got the information that circumstantial evidence is just as important as hard evidence when the plaintiff has the burden of clear and convincing evidence.
Any response?
Yes, Your Honor. Circumstantial evidence and hard evidence are both substantially probative in cases like this, especially where it's fact-specific. Given that there is no hard evidence in this case, it is reasonable that Ms. Ngoma can draw her expert testimony from the facts and the data surrounding this case. She has testified to Pollag, which is a nationally reputable polling company. She has testified to Exhibit F, where she has also drawn her conclusions. Under Evidence Rule 702.2, she has testified to the scientific, technical, and specialized methodology where she got this from. Therefore, it is admissible in court. And under Evidence Rule 401, whether or not this is circumstantial or hard evidence does not make this more or less probable. So it is not relevant.
Excellent argument, ladies. I'm going to overrule or sustain the objection. You're correct.
Yes, Your Honor. Now, Ms. Ngoma, I want to move on and talk to you about the Pollag polls. Now, earlier you stated that they're a highly reputable polling society, right?
That's correct. It's the #1 polling company in the entire country.
The #1 polling company in the entire country. Do you work for Pollag?
I do not. I simply analyze their polls as they put them out in the newspaper for elections all across the country.
Does anyone who works for Pollag work on your campaign?
I'm not actually sure because we have a
Objection.
rather large amount of people.
Your Honor, I re-raise my relevance objection. We have already established that Pollag is a nationally reputable polling company. Whether or not Ms. Ngoma works for them does not make it more or less probable that their data would be admissible in court.
May I respond to that,
Of
Your Honor?
course.
Your Honor, Ms. Ngoma has just established most of her testimony on the Pollag polls. I believe that the defense should be able to inquire about her first-hand knowledge about how Pollag polls are conducted, the credibility of these polls, because simply saying that they're credible is not enough evidence to establish that they are, in fact, credible, because Ms. Ngoma must rely on what she's either perceived or what has been admitted into court today.
May I respond?
You may.
Your Honor, as was addressed in pretrial, under Evidence Rule 901, both parties have stipulated that all exhibits are pre-admitted, therefore waiving any objections that they would have to Exhibit F specifically. We have already determined that Pollag is reputable, therefore I ask that we move on from this line of questioning.
May I respond to that, Your Honor?
It's unnecessary.
Yes.
You're winning this one. I'm going to overrule the objection. You can inquire in a limited nature, and the witness can answer if she knows.
Yes, of course, Your Honor.
Your Honor, can I ask for a continuing objection on this line of questioning?
You may. It's noted. It's overruled.
Thank you.
Sixth Circuit is unavailable.
Now, Ms. Ngoma, to your knowledge, does anyone on your campaign work for Pollag?
I believe my deputy campaign manager might have at some point. He used to live in New York before he moved to Harmony, although I'm not entirely 100% sure.
So going back to my original question, you don't know.
Well, no, as it's a national polling company, so I trust their polls. It's worked for me in multiple campaigns before.
And in fact, in today's case, although you've relied on the Pollag polls, these polls never asked the question, did you see the Latu video?
Well, as I said, what polling polls ask is, who are you voting for? So, surrounding circumstances, the context for the polls is something you gather from outside the statistics.
Right, Ms. Ngoma, they asked who you're voting for, but not why you're voting for them.
Not the Pollag polls, no, that's not how polls work.
The fact of the matter is, Ms. Ngoma, the only drop that your candidate saw was among the 50-plus age group, right?
That is correct, and it was a rather drastic drop, so if this video is not taken down, I don't know if we'll be able to recover from it.
You say if the video's not taken down, you don't know if you can recover, but Ms. Ngoma, that newspaper poll actually mentions not the Latu video, does it?
No, that's not what the journalist chose to focus on.
Right, the journalist chose to focus on that senior center event the same week those polls were conducted, right?
That's correct. However, I would like to point out, Ms. Bell, that the senior citizen event had a limited audience of 100 people, which is a very small majority of the elderly community represented in these polls.
I actually want to talk about that, because, to your knowledge, Saidi's opponents went to this event, didn't they?
They did, and they all chose to skip the 30 under 30 charity
Right.
auction.
They went to this event, and their numbers in the 50-plus age group rose, right?
Yes, as I mentioned earlier, that 10% undecided after the video came out moved over to OFEEC.
And your candidate didn't go to the senior center event, and her numbers in the 50-plus age group dropped.
That's correct. However, I would not say the two events are correlated.
I didn't ask if you thought the two events were correlated. I simply asked if
Objection. Asked and answered. May I be heard?
You may.
Under Evidence Rule 403, Ms. Ngoma has already testified that the numbers in the senior category did drop after this event. Asking this any further would cause unnecessary undue delay. We will stipulate that the numbers in that category dropped. If we can move on from this line of questioning.
Any response?
Yes, Your Honor, I was simply clarifying as the witness elaborated further from my original question.
Again, good arguments, ladies. It is cross-examination. I typically would give you a lot of latitude, but Ms. Greer is correct. I'm going to sustain the objection. Let's move on.
Yes, Your Honor. And the fact of the matter is, Ms. Ngoma, this was a simple 30-minute event, right?
It was, but it unfortunately coincided with the 30 under 30 event, and as that event had a larger audience and therefore would have had an impact on the polls, we chose to go to the 30 under 30 event instead.
It was an opportunity for your candidate to tell the seniors about her platform?
That's correct, but only 100 people was not enough to sway our polls in either direction.
But
so
you
we
don't-
chose to go to the other events.
But you don't know, because again, you never asked why. Yes or no?
Not in the polls, because that's not how they work.
And with that, I have no further questions.
Very well. Redirect. You may inquire when you're ready.
No redirect, Your Honor.
Ah, very well. Is this witness excused at this time?
The plaintiff rests.
Very well. Thank you, ladies. Is the defense ready to proceed with their case in chief?
Yes, Your Honor, the defense would like to call the defendant Wyatt Latu to the stand.
You may inquire when you're ready.
Yes, Your Honor. Good morning. Could you please introduce yourself to the court?
Good morning. My name is Wyatt Latu, and I'm a senior at Trillium High School.
What kind of activities do you like to do at school, Wyatt?
Well, it may come at a bit of a surprise, but I've never really been much of the athletic type. You wouldn't catch me wearing a red hat playing football. However, I am pretty good at math, though. You see, I've been on the mathletes team for a couple of years now.
Wyatt, why are you here today?
Well, a few weeks ago, I ended up getting in trouble with the principal of my high school, Miss Saidi, because I made a little bit of a mistake. A day or so later, Miss Saidi makes her own little mistake, and I decided to make a video kind of poking some fun at her a little bit.
Now, before we get to your video, I want to talk about the principal, Miss Saidi. What's your relationship like with her?
Well, we weren't in a relationship. I guess you could say we were cordial. You know, I wouldn't ask her to the dance. That is, until recently, we'd been bumping heads a little bit.
Why is that?
Well, a few weeks ago, coming back from this mathletes competition, I'll admit I did something pretty stupid. I'd brought in this old vape that I'd gotten from one of my cousins at the time because I wanted to look cool in front of my friend Minda. You see, we were looking at the inner functions of the thing when Miss Melnick totally busted us.
Objection. Relevance. May I be heard?
You may.
Under Evidence Rule 401, relevant evidence makes an issue more or less probable. This whole vaping incident does not make the issue of whether or not we should ensure a preliminary injunction more probable. Furthermore, under Evidence Rule 403, this is more unfairly prejudicial than probative towards Ms. Denver Saidi, as I anticipate this line of questioning is going to paint Ms. Saidi as having malicious intent towards Wyatt Latu, as Wyatt Latu just testified that Ms. Saidi was bothered by this and had something against Wyatt.
May I be heard?
Of course.
Firstly, Your Honor, Mr. Latu hasn't made any reference to the principal in this discipline at this point in time. Furthermore, in direct examination, opposing counsel opened the door by inquiring about this exact same discipline when it comes to Mr. Latu and the vaping incident, and therefore it'd be extremely relevant as a result because it lays the foundation as to clearing up the issue, as we do believe Mr. Latu should be able to give his side of the story.
Your response, Ms. Greer?
Yes, Your Honor. The intricacies of why they were holding the vape, why they wanted to look at the mechanics of it, does not make this issue more or less probable. If they do want to address the vape, I ask that we just do that without all the background story.
Again, great job on the arguments of those well-placed objections. The res gestae is something part of that I mentioned earlier. It's Latin for background information, so I'm going to let it occur at this moment in time for a limited purpose. I'll give you extreme latitude on cross-examination to ask all you want about this.
Yes, Your Honor. Were you finished with your response?
Yes, I was.
So you just mentioned that you were caught with this vape. Well, how was the principal involved?
Well, Miss Melnick went and told Miss Saidi, and Miss Saidi, being the principal of Trillium High School, she runs all the punishmental affairs. And so, a day or so later, I get called down to her office, and long story short, without really giving me a chance to explain that I wasn't actually vaping, all of a sudden I'm banned from going to the snowball dance, the real cream of the crop of dances of Trillium High School.
You say it's the cream of the crop of your school's dances. Did you have any plans for it?
Yeah, it's honestly kind of embarrassing to talk about in front of so much people, but I had been building up the courage to ask out my friend Minda at the time. You see, I thought she was into me, you know? I thought it was going to be our ultimate high school rom-com moment, but my chances were shut down.
So did you in fact miss the dance?
Yes, I ended up stuck at home while all my friends, including Minda, got to go.
Well, Wyatt, how did this lead to you creating your video?
Well, at the time of the dance, my friend Minda, she was texting me because I was at home about the details. Apparently some funny things happened, and she told me that she wished there was a video of the dance. And you know, since I couldn't go out with her, I mean, what else am I supposed to do? So, like a genie in a bottle, I got to making a video for her.
How did you make this video?
Well, I was using the principal's mistakes that she made at the dance, along with this physical live stream that was going on at the time. Using the text that Minda had sent me and the clips from the live stream, I inputted the details.
Objection. Hearsay may be heard.
You may.
Your Honor, hearsay are out-of-court statements being offered for the truth of the matter asserted. Wyatt Latu is using Minda's text messages as the truth of the matter, that what happened at the dance was a funny incident.
May I be heard?
You may.
Your Honor, these statements are exception to hearsay pursuant to Rule 803A, present sense impression, which states that statements made during or immediately after an event has occurred are exception to hearsay. In this case, Minda's statements are an example of present sense impression because they are directly during the event of the snowball dance speech, which is the event in question in today's case. Therefore, these statements would be made directly after or during that event and would be exception under 803A.
Good objection. I'm going to overrule the objection. Again, you may inquire about these if you like on cross.
Yes, Your Honor. Were you finished with your response, Wyatt?
I'll continue a little bit. Well, like I was saying, I entered the details into the AI generative prompt on my computer program, and it got to uploading this video playing off of some of Mrs. Saidi's mistakes.
Now, I want to talk a little bit about these mistakes with you. Could you please flip to what's been previously marked as Exhibit A?
Yes.
Now, do you recognize what that is?
Yes, I do. It's the shorter transcript compared to Exhibit B. It's the transcript of Saidi's actual speech that she gave at the dance.
And could you flip to Exhibit B and tell us what that is?
It's the longer transcript. It's kind of like a cake without the icing. It's the transcript of my AI parody video, but without the visual details that I tied in.
Now, you mentioned previously that you made this video playing up the principal's mistakes. What were those mistakes, Wyatt?
Well, Miss Saidi was talking about politics in front of a bunch of students. She mispronounced the name of a student and also made a joke about coming from a bar.
I'd like to break down these mistakes one at a time. Starting first with the campaigning mention. What did the principal do?
Well, Miss Saidi said that it was moments like the dance that really remind her why she's running for city council in the first place.
So given that, what did you do in your parody?
Well, as if the principal of my high school doesn't talk about politics enough, I decided to have a little bit of fun with it. And so I had Miss Saidi calling all the kids losers, and I had Saidi as a big popular kid. I had her saying, you know, tell all your parents, vote for me, make me the next big popular kid of Harmony.
Now, you also mentioned that the principal made a mistake with a mispronunciation of a name. What exactly happened?
Well, at Daniel Jenkins's big moment of being announced as the Snow King, Miss Saidi goes Danielle Jenkins instead of Daniel Jenkins.
So how did you incorporate that into your parody?
Well, I pretty much did the same thing. Except before this, I added in some finger guns, pew pew, pow pow, just to be a little funny for Minda. And then I had Miss Saidi saying, Danielle Jenkins. That's right, Danielle Jenkins, get on up here for the Snow King.
And lastly, you mentioned that the principal brought up a bar at the school dance. Could you tell us where she does that?
Yes, I can. So right after Miss Saidi mispronounces the name of Daniel, she goes, maybe she shouldn't have spent the afternoon at Rossi's. Then she wouldn't have made that mistake.
So given that, how did you incorporate this information, this mistake, in your parody?
Well, since the principal of my high school is making a joke about a bar in front of all the students, I thought it was a perfect opportunity to have a little bit of fun with that. And so I had Miss Saidi slurring on and off throughout her speech, and I even had her drop a similar joke. Maybe she shouldn't have spent the afternoon kicking it back with old Melnick at the bar. But honestly, at this point, I felt like my parody video, it needed a little more oomph to it. Shows like Saturday Night Live, they all have that core moment that really make their shows so great. And so to have this oomph, I had Miss Saidi flip her campaign. I had her saying she was running from the police.
Now, Wyatt, just to be clear for the members of the court, who was it that made these mistakes first?
Well, it was all from Miss Saidi. I mean, the politic mentioning, the mispronunciation, and the bar joke, it was all first from Miss Saidi.
And why did you decide to make this video?
Well, I wanted to be a little funny for Minda. Maybe she'd be kind of into funny guys. But also, I wanted to comment and critique on Saidi's character. I've always been into political comedy. It's how I've participated in political conversations growing up. You see, I believe in a democracy, citizens should have the right to comment or critique on our potential future leaders. And well, since Miss Saidi is running for city council, I thought the people should look into the mistakes a little more that she made.
So after creating your video, what'd you end up doing with it?
Well, it was my very first debut to the app Tactic. I uploaded it. Shout out to @Latu give me a follow. And it got 5,000 views to my surprise. I mean, even Theo and Ngoma shot me an email about it.
What exactly did that email entail?
Theo and Ngoma asked me to take down my creation, my video.
Did you agree with Ms. Ngoma's proposal?
I mean, no, of course not. I felt like I shouldn't be silenced right now. I mean, way back when I first got in trouble for quote-unquote vaping, when I got called down to the principal's office, Miss Saidi didn't really give me a chance to explain that I wasn't actually vaping before banning me. And so now that I'm making a video playing off of some of Miss Saidi's mistakes, all of a sudden I'm being asked to take it down. I felt that it would be a disservice to all parodists in the world right now.
Objection. Move to strike the witness's answer as improper character evidence. Under Evidence Rule 404, evidence of a witness's character for truthfulness or untruthfulness may be asserted. Wyatt Latu is once again trying to paint Miss Saidi as someone having malice against Wyatt Latu when she was simply carrying out a standard disciplinary action. I ask that Wyatt Latu's answer be stricken as improper character evidence.
May I respond?
You may.
Your Honor, this line of testimony is not going towards the character of Principal Saidi. It's simply laying the foundation for why Mr. Latu doesn't believe the video should be taken down. All Mr. Latu mentioned was the fact that the principal disciplined Wyatt over his mistakes, and as a result, he believes that he should have the same leeway to essentially emphasize the principal's mistakes. There's no mention of any malice or any sort of character attack on the principal themselves, but rather a rationale for why Wyatt Latu acted that way.
Any response?
Yes, Your Honor. Wyatt Latu just said that Miss Saidi did not give him a chance to explain before banning him from the dance. This is painting Miss Saidi as an authoritative figure that is acting unfairly. This does not go to the truthfulness or untruthfulness of Miss Saidi and is painting her in an improper, unfavorable light.
May I respond?
I'll give you a chance.
Yes, Your Honor. We believe that goes towards the weight of the evidence and not the admissibility. If opposing counsel wants to cross on the exact wording Mr. Latu used, that would be fair in cross-examination. However, we believe that this does not hold any ounce of evidence as to the character of Principal Saidi, rather than his rationale for why he decided to neglect this offer.
Again, excellent objection, well argued. I'm going to overrule it. You can inquire on cross-examination.
Yes, Your Honor. Were you finished with your response, Wyatt?
Yes, I think so.
So, we heard today that Theo and Ngoma asked you to take down the video, and you didn't agree. Did you ever try to negotiate anything with her?
Well, yes. I even went as far as to offer to sell the rights of my video to Miss Ngoma. She ended up declining my offer. I mean, if she bought the rights, she could have, edited the video, added a disclaimer, or even took it down, but she chose not to take my deal.
So to be clear, Wyatt, how could this whole situation have been resolved?
Well, all Miss Ngoma had to do was purchase the rights of my video. Then she could have taken it down, put a disclaimer, but she chose not to.
Thank you, Wyatt. I have no further questions.
Cross-examination, you may inquire when you're ready, counsel.
Yes, Your Honor. May I proceed? Before we begin today, do you prefer I call you Mr. Latu or Wyatt?
Mr. Latu, please.
All right, Mr. Latu. The only time you have used digital editing software to manipulate a person's likeness is because you were upset with them.
Yes.
Yes, there was a bully your freshman year of high school.
Yeah, he always picked on me for being a little small and tiny. I
Right,
kind of
so-
still am.
Right, this was a person who was...
Objection, Your Honor. May I be heard for improper character attack?
You may.
Your Honor, this line of testimony is an improper character attack under Rule 404 because it's providing an example from the past showing that Wyatt Latu uses this type of technology because he was upset with an individual, showing that in this case he would have the same propensity to act in a way against the principal. As a result, because Rule 404 rules that any character of evidence that shows propensity to act in a certain way in the near future is inadmissible, we believe that this directly relates to that as well.
You may respond.
Your Honor, in our simplified rules of evidence, Rule 404 does not prohibit prior bad acts. However, if opposing counsel is arguing 404 as it exists in the Ohio rules of evidence, this would still be an exception under motive and intent. Most importantly, Your Honor, the first issue in today's case is likelihood of success on our defamation claim. A prong of defamation is actual malice. This line of questioning goes to show that Wyatt Latu uses digital editing software with a malicious purpose.
May I respond?
You may.
Your Honor, first and foremost, we are only relying on the OCLRE rules in today's case, or the Ohio rules. And second, by showing this witness's malice by using a past event that is directly inadmissible under Rule 404 because it shows propensity, inferring that Wyatt Latu, acting this way in the past, has acted in the exact same way in today's case, which would be improper character evidence.
May I respond?
It's not necessary. You won this one too. No, overrule the objection. It's cross-examination. You can inquire and rehabilitate the witness if you believe it's necessary on redirect.
Yes, Your Honor.
So there was a bully who was unkind to you.
Yeah, I wouldn't say he was hyping me up.
Right, so in your own words, to give him a taste of his own medicine, you photoshopped him.
Yeah, I mean, it was a more simple way to, make his face look big, make him the silly figured one instead of me being the tiny one.
Right. Moving to your relationship with Miss Saidi, you do not like your principal, do you?
Well, yes, I don't like most of the staff in general at Trillium.
The principal who, after discovering your vaping incident, banned you from the snowball dance.
Yes, that's right.
And you just told us on direct examination that this dance was a big deal.
Yes, I mean, I was going to ask out old Minda to the dance. It's going to be my chance at a senior romantic moment.
Right, so you were not happy about the punishment that Miss Saidi gave you.
Yeah, I guess at first I was obviously upset. Eventually I got over it though, but of course at first I was going to be a little upset not being able to ask her out.
Well, in your witness statement, you said you mostly got over it. Isn't that right?
Yeah, mostly. I mean, you have some memories of the past, when that old jock called me small. I mean, I got over it, but I still remember it,
So you were mostly over it, but not entirely. True?
Yeah.
And then, in your own words, there was the perfect opportunity for revenge.
Yeah, I mean, what's good for the goose is good for the gander. Miss Saidi was making all these mistakes, and, I thought it was a perfect opportunity to get a little even Steven poking fun at the jokes by amplifying them up a little for parody.
So in revenge, you created this AI-generated video of Miss Saidi. Isn't that right?
Yeah, to get a little even Steven, to poke some fun.
And you uploaded this video not just to Minda, but to Tactic.
I uploaded it to Tactic, and then I showed Minda.
So it wasn't just shown to Minda, it was posted somewhere else.
Yeah, my first post to my Tactic account.
And you made this first post faster than you can say sabotage?
Yeah, it was a 3-syllable word that I just happened to come up in my mind at the time. Like sashimi, octopus.
So you just happened to think of the word sabotage, isn't that right?
Yeah, I do a lot of thinking on the Mathletes team.
So upon uploading this video, isn't it true that it was more than a joke?
Yeah, I wanted to comment on Saidi's character a little bit. As I said earlier, I don't like most of the staff at Trillium in general, and this is just how I participate in political conversations.
Yes, so you just testified this was more than a joke, and because of this video, you wanted people to see that Denver Saidi was not fit to be on city council.
Well, I wanted people to interpret my art however they wanted to. It's art, it's expression. People should be able to take what they think from my art and interpret in ways that they want or to perceive in.
Bringing you back to my question, Mr. Latu, your intention of this video was to get people to see that Denver Saidi was not fit to be on city council.
Well, yes, but I also wanted to be funny, and I also wanted people to interpret it in more ways than just that as well. People can interpret it in any way they want.
But the way you wanted people to interpret it is that Denver Saidi was not fit to be on city council.
Yes,
Objection,
but there's
Your Honor.
more to
As
it.
to ask and answer, I believe this witness has already claimed their intent as to whether or not this video's purpose was for the principal to be unfit.
Response?
I can move on, Your Honor.
Very well. Thank you.
Yes, Your Honor.
You, in your own words, did not mind if people thought this was the real Denver Saidi.
Yes, while it was never my intention, I didn't mind because, I thought people would find it funny. And again, art is up for interpretation. They can interpret it how they want.
I'm no longer asking about your intention, Mr. Latu. You did not mind if people believed this was the real Denver Saidi. That's a yes.
Yes, I didn't mind.
Thank you. No further questions.
Redirect. You may
Yes,
inquire.
Your Honor. Now, Wyatt, before I continue, I know it's your first time in court today, but could you please step a little bit back from the mic?
My bad. I like amplifying my voice.
All right. Now, Wyatt, on cross-examination, opposing counsel asked you about whether or not you were over the events of the discipline during the snowball dance. How were you feeling?
Well, I'd pretty much gotten over it. It was a while ago.
Thank you, Wyatt. I have no further questions.
Recross.
No recross, Your Honor.
Very well. Is this witness excused at this time?
Yes, Your Honor.
You may call your next witness and inquire when you're ready.
Yes, Your Honor. At this time, the defense calls Emery Popovic to the stand. Good morning. Could you introduce yourself to the court?
My name is Emery Popovic, and I'm a freelance parodist and consultant.
Now, Ms. Popovic, could you tell the court more about yourself?
Well, I was born and raised in Harmony, and then after school I decided to move my 4 youngins and I out of town.
Now, Ms. Popovic, could you tell the court what you do for a living?
Well, as a parodist, I like to think of it as being a bit of a comedian. You see, as a parodist, we try to mimic a person or a situation, but we exaggerate the flaws like a show pig at a county carnival. But instead of lipstick on a pig, we use humor and irony, like to get people to either laugh or think more deeply about a subject.
Well, Ms. Popovic, could you tell the court about where you could find these types of parodies?
Well, finding a parody ain't like finding a needle in the haystack. You can find them on TV like Saturday Night Live, or with different types of writings like blogs, articles, or magazines, or even now with artificial intelligence like AI.
You just mentioned AI. Do you have any certifications in relation to that field?
Of course, with the growing advancements in technology, I decided to go get myself a certification in machine learning and generative AI, which is the generation of sounds and inputs through inputs on a computer.
Now, Miss Popovic, do you have any other education related to the field of parodies?
I do. I have a BA in Media Studies and Communications from Buckeye State University and a master's degree in Fine Arts and Creative Writing from Case Western Reserve.
Do you have any experience?
Well, other than running my own consulting business, I got to be the lead writer at Buckeye State's paper and got to found my own digital media publication called The Shallot at Case Western Reserve. In both papers, I got to deal with parodies and satire to make comments on celebrities, politicians, and campus news and events.
Do you recall how many of these articles you've written?
I wouldn't say to infinity and beyond, not to quote Toy Story or nothing, but definitely a couple hundred.
Now, Miss Popovic, earlier you mentioned that you have your own consulting agency. Have you ever testified in connection with that agency?
Yes, I have, primarily with AI being used to create parodies.
And when you provide an opinion in court, are they to a reasonable degree of professional certainty?
Of course, that's the job of a forensic expert. You need to consider the legal, the ethical, and the technical aspect before providing an opinion.
So, Ms. Popovic, it's fair to say that you rely on reliable scientific or otherwise specialized knowledge, then?
Yes.
Your Honor, at this time, the defense moves to tender Ms. Emery Popovic as an expert in digital medium, specifically AI, in relation to the creation of parodies.
Any objection?
Yes, Your Honor. Well, we will agree with Ms. Popovic being admitted as an expert in generative AI. Not enough foundation has been laid to tender her as an expert in parody. May I be heard?
You may.
According to Rule 7021, a witness must demonstrate that they have specialized training, education, or experience. However, Ms. Popovic has not laid any foundation that she has any training in parody, any education in parody, and the last time she personally and professionally wrote satirical content was over 11 years ago on The Shallot. Furthermore, while opposing counsel has said that she has testified in a court before, they have also left out that she has been excluded as an expert in multiple courts.
May I respond to that, Your
You may.
Honor? Well, opposing counsel is correct. 702A does state that an expert must rely on education, training, or experience. The fact of the matter is she only needs one. And Ms. Popovic has established that she has the necessary experience and training because she has written countless hundreds of articles, satirical articles, and although those were many years ago, she is still a political consultant and constantly testifies in court like today. And when it comes to opposing counsel's argument that her testimony has not been allowed in certain courts, this is a separate court, Your Honor. And this is up for you to decide whether or not her opinion should be admitted. And that goes to the weight and not the admissibility of her testimony.
Any response, counsel?
Yes, Your Honor. Since the last time that Ms. Popovic personally created parody 11 years ago, she has made her living solely by testifying as an expert in court. Therefore, there is no reasonable expectation that she should still be admitted as an expert here today.
May I respond to that, Your Honor?
It's unnecessary. You're winning this one. I'm going to overrule the objection. It was well placed, Ms. Folk. I'm going to allow you to inquire as to your credibility and the lack of time from her last article on cross-examination.
Yes, Your Honor.
You may continue.
Now, Ms. Popovic, could you explain your involvement in today's case?
I was obtained by the defense counsel to analyze Wyatt Latu's video and Principal Saidi's speech to determine if Wyatt Latu's video is a parody.
To be transparent, were you compensated for your time?
Working 9 to 5, as Miss Dolly Parton says, so yes, I get paid at standard industry rates. I get paid $3,000 for my 8-hour analysis and $10,000 for my time and expenses related to this hearing and its potential to go to trial.
And what exactly did you rely upon when coming to a final opinion today?
Well, after receiving the generic background info, I primarily utilized Wyatt Latu's video and Principal Saidi's speech.
Your Honor, it's my understanding the court has exhibits A and B. Ms. Popovic, could you please turn your attention to exhibits A and B? Now, do you recognize these exhibits?
Yes, these are the transcripts of the videos I analyzed. However, I didn't use the transcripts because you lose a lot by not being able to see the absurd visuals and the audio.
Now, Ms. Popovic, let's take a step back for a second. How do you usually approach determining whether or not a piece of media is a parody?
Yes, well, I have to understand the technology being used, which in this case is AI. From there, I can understand how it's being presented. From there, I have 3 main focal points: the visuals, the statements made, and the overall content and context of the video to determine if it's a parody.
Now, Ms. Popovic, let's start with the first one. In today's case, what technology was used?
In this case, we're looking at deepfake technology. However, the quality is like eating a soggy biscuit. But deepfake technology is a subset of AI where a computer generates a lifelike image of a speaker. Then the artist takes that image and has them say statements or comments that they made in real life to some extent, but rather bedazzles or makes them more bigger.
More bigger. Okay. Ms. Popovic, you just said that the deepfake was like eating a soggy biscuit. What do you mean by that?
Well, that ties into my first element of analysis. Do the visuals lead a reasonable person to interpret the video as fake?
So what did you find when you looked at that first factor?
What didn't I find? Saidi's hair was on her head, off her head. Sometimes she was standing next to her hair. It's like seeing Miss Dolly Parton being her big, blonde, beautiful self one second, then being bald the next. It's just wrong.
Was that all you found?
No, the fingers were being bent at inhuman angles while Saidi was doing these weird rootin' tootin' finger guns. And then the lips.
The lips?
Oh my golly gosh, they sure as heck wouldn't win no awards at a lip syncing contest.
So what did you find when you looked at the second factor, the statements made?
The words, the vocabulary, Saidi saying things like big, popular kid, belle of the ball when announcing the snow court, and calling this group of students a bunch of losers is completely out of pocket for a principal. It'll make you spit your sweet tea out.
And what about the last factor, the context of the video?
Well, when you look at the AI video, Saidi talking about their campaign for the first half. They then go and mistake the student's name as Danielle instead of Daniel Jenkins. Then they correct their mistake by saying they shouldn't have gone to a bar, Rossi's, and then they were doing the Fast and Furious with the police. However, all this is said to mimic the original video in some respects or reference Saidi's campaign.
Well, how does it mimic the original video?
Well, if you look at the original video, Saidi does talk about their campaign. They do mispronounce the Snow King's name, and they do make a joke about attending Rossi's.
And what about their campaign platform? How is that implemented in Latu's video?
Well, Saidi is running on 2 platforms: education reform and drunk driving awareness. Hence, the running away from the police and drinking at Rossi's.
So after you looked at all of these factors, were you able to come to a final conclusion today?
Yes, with the train wreck visuals, the outrageous statements, and the overall content and context of the videos, it was clear that no reasonable person would ever think that this video is real.
Objection, Your Honor. Move to strike the witness's answer as an improper expert opinion. May I be heard?
You may.
At this time, the witness's answer has not been held to a reasonable degree of certainty, which makes her testimony speculative. As it is now, this testimony is no different than a lay opinion.
May I respond, Your Honor? Ms. Popovic has already been tendered as an expert. She has already testified that she relies on reliable, scientific, or specialized knowledge. She has already testified today that when she comes into court, she provides opinions to a reasonable degree of professional certainty. In addition to that, in accordance to Rule 705, she has laid the basis of her opinion before she gave that opinion, and therefore she has satisfied all the prongs, Your Honor.
Response?
Your Honor, again, it has not been held to a reasonable degree of professional certainty, not to parody, not to generative AI, which means that this opinion is an improper expert opinion.
May I respond to that, Your Honor?
You may.
Nowhere in the rules does it state I have to explicitly ask that before she provides a final opinion. In addition to that, I already asked earlier, that when she provides opinions to the court, does she provide opinions to a reasonable degree of professional certainty. She has already satisfied 705, and she has already satisfied 703, which says she must rely on what she has personally perceived or what was admitted into evidence, and because both rules have been satisfied, her opinion should be able to come through.
I'll sustain it in part. Perhaps you asked him if she's making it as a lay or an expert opinion.
Yes, Your Honor. And was that opinion an expert opinion?
Correct, it was.
With that, I have no further questions, Your Honor.
Very well. Cross-examination, when you're ready, you may inquire. Ms. Volk.
May I proceed? Ms. Popovic, you were retained on January 9th by Mr. Liu and Ms. Bell to testify.
Correct.
And since deciding to take on this case, you have charged $3,000 for your services.
Correct. $3,000 for my 8-hour analysis, standard industry rates.
Well, on top of that $3,000 charge, you plan to charge an additional $10,000 if this hearing is to proceed to trial.
The $10,000 also includes my time and expenses related to this hearing, like flying in and out.
Well, you said that $2,000 would be for travel expenses, correct?
Correct.
So excluding those, that would be $11,000 to watch, review, and testify on a 1.5-minute long video?
Well, I have to review the why it is a parody, so that takes me multiple hours sometimes. But also, I don't know how long a hearing could take. Sometimes it's a 3-day expenditure.
Your Honor, move to strike the witness's response as unresponsive to my question. I simply asked her if it was $11,000 she would charge in total. She went on to explain why and has yet to answer my original question.
Response, Ms. Bell?
Yes, Your Honor. My witness responded yes, because I have to, it might be a 3-day expenditure, and I have to cover travel expenses. If opposing counsel wants to redirect her back to my question, she's more than welcome to, but I don't think it's necessary to strike her testimony.
Thank you, ladies. It's a it was an excellent objection. I'm going to sustain your objection. It will be stricken from the record. The counsel would like to ask the witness to answer her questions directly. If she fails to do so, you can instruct the court to admonish her accordingly.
Yes, Your Honor.
You are charging $11,000 to review this 1.5-minute long video.
Correct. Standard industry rates.
Well, let's talk a little bit about your qualifications within your industry. You refer to yourself as an expert funny person, correct?
Correct.
But the last time you personally and professionally wrote satirical content was over 11 years ago.
That's when I produced the funny content. Now I analyze it.
So yes, that was 11 years ago.
Correct, Domingo.
Well, since then, for these past 11 years, you have made your living solely by testifying as an expert in court.
Yes, writing satire and parodies and creating videos weren't enough to feed my kids.
Well, let's look at your analysis of this video. As part of your analysis, you reviewed the matter, the context, and the video itself, right?
Correct.
Well, let's just look at the matter. You've said that in order for something to be parody, it must mimic, not mirror the original.
Correct, that's one of the factors of parody.
Well, in Miss Saidi's original speech, she mispronounces Daniel Jenkins' name as Danielle, right?
Correct, as also seen in the AI video.
So correct, she does also mispronounce Daniel Jenkins' name in the AI video.
Correct.
The AI video does not have Miss Saidi mispronouncing any additional names?
No.
Again, in the original video, Miss Saidi mentions going to Rossi's prior to coming to the dance.
Correct, a bar.
And in the fake video, she also mentions attending Rossi's prior to the dance.
Correct.
She doesn't mention any additional bars in the fake video.
No, she does not.
Let's talk about the context of parody, the importance of context in parody. Now, according to you, on direct examination, you have posted and created hundreds of satirical articles and videos, right?
I have.
Now, when you were affiliated with those were posted on the Shallot, which is a digital satirical newspaper, right?
Correct, a digital media publication.
So when you were affiliated with the Shallot, not only was your parody content on a parody website, it was surrounded by other obvious parodies. Isn't that right?
Correct, especially when it was more well known.
Well, let's contrast this to Mr. Latu's video. That was published on Tactic, correct?
Correct.
Now that is a social media site rather than a satirical website.
Yes, that is true, but Tactic is a social media site where plenty of parodies are published.
But it is a social media site nonetheless.
Correct.
Top of that, this is the only video that is posted on Mr. Latu's page, correct?
Yes.
Ms. Popovic, there's no caption on this video.
No, why ruin the punchline?
There's no disclaimer that this video was AI generated.
No.
On top of that, the name of this account was Latu Lombardi, correct?
Correct.
Let's talk a little bit deeper about deepfakes. In order for something, you've said that deepfakes have the capability to create highly realistic, but sometimes misleading, videos, images, and audio. Isn't that right?
Correct, just not in this case.
Well, you've also said that deepfakes, as AI technology, are the most susceptible for misuse.
Yes, in high-profile cases, just not this one.
Well, let's talk about this case then. You said that you believe that this was obviously a deepfake.
Correct.
But you did review this video for 8 hours.
That's the why. Anyone can tell you that something is fake or it's a parody like seeing an SNL skit, but they have professional writers to tell you the why. I'm here to tell you the why it's a parody.
So yes, you reviewed this 1.5-minute long video for 8 hours.
I reviewed both videos to tell you the why it is a parody.
You wouldn't expect the average viewer to review this video for 8 hours?
No, because as I said, it's obvious that it was fake, but I'm here to tell you the why.
Additionally, you watched this video, the fake video, frame by frame.
Yes, to tell you the why.
You wouldn't expect the average viewer to watch this Tic Tac video in that way.
No, because it is a fake video is obvious. I'm here to tell you the why.
Well, finally, let's just talk a little bit about your methodology. In your affidavit, you state that people have questioned whether consulting on about parody and deepfakes is a real field.
Yes, but I can assure you it is.
Well, your technique for analyzing this particular deepfake has not been scientifically or otherwise tested.
Can you please explain your question?
Ms. Popovic, you're claiming to be an expert in analysis of parody deepfakes, and yet you don't know what it means to be scientifically tested?
I did not need to use advanced forensic analysis because it was so obvious. I was able to just look at it myself frame by frame. It was obvious that it was fake, and it was obvious to me that it was using deepfake technology. So I did not need to use any advanced machinery to make sure that it wasn't the real speaker.
But back to my question, it has not been scientifically tested or reviewed.
Not with forensic analysis. No, not with advanced forensic analysis.
Furthermore, your technique has not been subject to publication or peer review.
No, because it was obvious.
You do not cite a known error rate for this technique.
No.
You do not cite any standards or controls in your creation of this technique.
The control was the original video.
I wasn't referring to the analysis, I was referring to your technique itself.
No.
And finally, you do not make any reference in your affidavit as to whether or not this testimony has been widely accepted.
Well, I'm here as an expert. I'm telling you that it is a parody. It's obvious that it was fake. I can go over my reasoning again if you need me to.
Your Honor, move to strike the witness's response as unresponsive to my question. I simply asked if it was widely accepted in her field, and she went on to just say that she is an expert testifying about her reasons. That is no way responsive.
Any response?
No, Your Honor, I believe if opposing counsel would like to redirect her, she may.
In this context, I would suggest counsel ask the witness in a yes or no format to answer only with a yes or no, and if she fails to do so, then I can strike it from the record in the future.
Yes, Your Honor.
Yes or no, Ms. Popovic, your technique in analyzing this deepfake has not been widely accepted by the community.
In my consulting business, it is.
Well, you don't cite a single other expert in your affidavit that also uses this technique.
No, I do not.
Well, Ms. Popovic, while you've been admitted as an expert in court here today, you've also been excluded multiple times by multiple judges, isn't that right?
Correct. They had a questionable sense of humor.
No further questions, Your Honor.
Very well. Redirect, Ms. Bell.
Briefly, Your
You
Honor.
may
but
inquire when
before
you're
I-
ready.
Sorry, before I proceed, may I get a time check from the
Of course.
timekeepers?
You have 2 minutes and 52 seconds left.
Briefly, Your Honor.
You may inquire when you're ready, Ms. Bell.
Now, Ms. Popovic, opposing counsel just asked you a lot about the deepfake technology used. In this case, would you say, in your expert opinion, that this was deceptive?
Absolutely not.
In your expert opinion, what kind of deepfake was it?
It was an amateur one. Bless his heart to Wyatt Latu, but this was nowhere close to good.
And opposing counsel also mentioned the fact that sometimes your testimony was not used in court. How many times have you testified?
A lot.
With that, I have no further questions, Your Honor.
Very well. Recross, counsel.
No recross, Your Honor.
Very well. Is this witness excused at this time?
Yes, Your Honor, at this point, the defense rests its case in chief.
Thank you. Witness excused. This concludes the portion of the presentation of witnesses. I think we'll start the timing for preparation of your closing arguments. I believe you're entitled to 2 minutes. Is that correct?
Yes, per mock trial rules, that's correct.
Very well.
Yes,
I
sir.
read those. If the timekeepers and bailiff would set 2 minutes and let me know when that time expires, we'll do that. All right, counsel, time has expired. Is counsel ready to make their closing arguments?
Yes, Your Honor.
All right, you may proceed accordingly.
May I proceed?
You may.
May it please the court. The defense claims this harmful video was a joke. But damaging the electoral landscape is nothing to laugh about. By abusing technology, the defendant poisoned the waters of this election. And a preliminary injunction is needed to dam the flood of false information causing irreparable damage downstream. At the beginning of this hearing, my co-counsel, Ms. Folk, outlined the necessary elements for a preliminary injunction. We have demonstrated these elements by clear and convincing evidence. First, there is a substantial likelihood that Ms. Saidi will succeed on the merits of her defamation claim, because this AI-generated video made false and defamatory statements. We heard from Ms. Saidi today that she is running her campaign on a platform that focuses on drunk driving prevention, strengthening the police force, and educational reform. However, Wyatt Latu's video falsely portrays Ms. Saidi not only as being drunk, but as driving while intoxicated and evading the police on the way to a school event. And Wyatt Latu acted with actual malice in creating and posting this video. We heard on cross-examination today that Wyatt Latu made this video as revenge to get even Steven. Wyatt Latu is no novice prankster. Motive and malice are clear. A principal rightfully disciplined a student, and the student sought revenge. Wyatt Latu published this video as a tactic to expand its reach and did not mind if people believed this was really Denver Saidi. Did not mind if this caused harm. Now, in an attempt to refute this as parody, the defense called an expert funny person who told us this video was parody, a joke. However, we heard on the witness stand today that AI posts like this can create highly realistic and misleading content. Now, in open today, Ms. Bell addressed Cheetah Minor. But upon reviewing this case, we see there was no AI, there was no parody. But what we learned in Farrah v. Esquire magazine is that context is key. Ms. Popovic told us today that there were no captions on Wyatt Latu's video. It wasn't surrounded by other satirical content. There was no disclaimer saying it was false information. And finally, Ms. Popovic's expert opinion is based upon unreliable methodology. It's junk science. There are no standards or controls, no known error rate, no evidence it's widely accepted in the scientific community. And finally, their testimony has been excluded by other courts. Second, irreparable harm has occurred and will continue to occur if this video is not taken down now. In the case of Fisher Development Company versus Union Township, the court held that irreparable harm had occurred because reputational harm was so great there was no adequate remedy at law, as in the case of Ms. Denver Saidi. We heard from Ms. Theo and Ngoma today, an expert in campaign management and poll analysis, who told us it was not a mispronounced name, it was not an absence from a small senior event with only 100 people in attendance. It was this video, this fake video created by the defendant, that caused the precipitous drop in Ms. Saidi's polls. Ms. Ngoma explained these graphs. Before the release of the video, Denver Saidi is trending towards success. After the release of the video, the polls of Denver Saidi plummet. It is just that clear. Given there are no third parties in this case, I am led to the fourth and final element. Granting a preliminary injunction will serve the public good, because it is always in the public interest to protect the violation of a party's constitutional rights. You cannot yell fire in a crowded movie theater, you cannot shout bomb at an airport, and you cannot post defamatory lies that derail an otherwise close election. The people of Harmony deserve to vote based on the truth, and Ms. Saidi deserves a reputation restored. To protect the rights of the plaintiff and the people of Harmony, I ask for a preliminary injunction. Thank you.
Thank you, counsel. Counsel, you may proceed when you're ready.
Yes, Your Honor. Your Honor, opposing counsel, may it please the court. A moment ago, the plaintiff told you that our elections cannot be a joke. But we'd beg to disagree, because it'd be certainly boring if every single election cycle year after year was just yes sir, no sir, straight seriousness. Because that's the beauty of how America works. We have the right to criticize our politicians in serious and funny ways, whether it be through parodies like Saturday Night Live, political satire cartoons, or magazines. It's those types of free speech that are continuously protected. In fact, cases like Novak, Farrah, Corso Ventures all identify that these protections don't rise or fall even if a few people are upset. And today the plaintiff has the burden of clear and convincing evidence, but they haven't met any of their prongs today. Starting with the first one, showing a substantial likelihood that the defendant's video was defamatory. Members of the court, the definition for defamation is a false publication that causes injury to a person's reputation, as defined by Corso Ventures. Members of the court, what you learned today is that it wasn't defamation at all, it was simply parody. Starting with the visuals of the video, you heard from Miss Emery Popovic that the visuals are absolutely crazy. Boom, boom, bam, finger guns, hair, reappearing and disappearing the next frame, fingers twisting and bending at inhuman angles. It sounds ridiculous to say out loud because it is. Members of the court, as the average reasonable viewer test in Farrah tells us, a reasonable viewer would have identified these visual features to be likeness of a parody. And as for the context of the video, you heard today that the principal's mistakes were the only basis for Wyatt Latu's video, because it was the principal who brought up her campaign at the school dance. It was the principal who mispronounced the student's name, and it was the principal who brought up a bar in front of her students. All Mr. Latu did was embellish these mistakes, exactly what parody is and serves to do. Highlight our governmental officials' mistakes, holding them accountable. And that's exactly what you heard today, and exactly why the plaintiff hasn't succeeded on clear and convincing evidence today, showing the video was defamatory. But as to the element of irreparable harm, they've further failed once again. Because you heard today that all Theo and Ngoma had to do was pay the cash. Cash for the video, and as Cheetah Minor tells us, monetary damages are not irreparable. So all she had to do was simply pay. And now today the plaintiff got up here and essentially held our expert under fire, but I'd like to do the exact same thing. Because when coming to her analysis of why the polls changed, you heard today that she didn't need to know the why. That all she had was circumstantial evidence. Members of the court, that's the same as saying as if a dog in Moscow died and a person shot a gun in the air in China, those two events are somehow related. But members of the court, the circumstantial evidence is not clear and convincing evidence. And because of how high their legal burden is today, they have not met that claim whatsoever. Because today, they never asked the fundamental questions of why. Did you see the Latu video? Did the Latu video change the way you were going to vote? They didn't ask any of the fundamental questions for the why. They simply gave you circumstantial evidence, not clear and convincing. Circumstantial evidence, which they tried to tie in with Exhibit F. And members of the court, what did you learn today? That the only drop in the polls was in the over 50 age category, the same week as the senior center event. And while Saidi's opposing candidates rose in the polls, she dropped because she snubbed the senior citizens. Members of the court, today, the plaintiff hasn't shown clear and convincing evidence. At best, they've shown exactly what Theo and Ngoma told you today, circumstantial, which does not meet the legal threshold. Members of the court, politics certainly don't have to be funny, but in the same respect, they certainly can. It's what makes our political system so special and so cherished. And just because Wyatt Latu made a parody that the principal was unfortunately the punchline for, it doesn't give them the right to silence Wyatt Latu's free speech, because it sets a dangerous precedent for the future. It's why we ask for a denial of a preliminary injunction. Thank you.
Thank you, counsel. Rebuttal when you're ready.
May I proceed?
You may.
May it please the court. The defense has told us that parody is protected speech, but defamation is not. The defense wants us to believe that this defamatory content is protected under the First Amendment as free speech. However, you cannot hide behind the First Amendment, as it does not provide unlimited rights to speech when that speech causes harm in the way it did to Miss Saidi. Now, for this to be protected as parody, we heard on the witness stand today that it would have to mimic, not mirror. But really, the differences weren't all that great. Both speeches made a joke about Rossi's. Both speeches mispronounced a name. Both speeches were a realistic-looking video. It took an expert 8 hours to figure out why. The average viewer would probably swipe on this on their phone for about 2 minutes. This was no longer the reasonable viewer and cannot be held as reasonable testimony, as we saw in the case of Corso Ventures. Now, if the court allows this defamatory content, this abuse of technology to plague the polls, they would be opening the floodgates to more unfair and corrupt elections in the future. Contrary to the defense, our elections are not a joke, and the electoral landscape cannot become a laughing matter. On these grounds, the plaintiff asks for a preliminary injunction to protect the rights of our electoral landscape. Thank you.
Thank you, counsel. That concludes the trial. At this portion, I will excuse the scoring judges to begin their deliberations. Give the judges a big hand. And give this wonderful group of young people a big hand. I have a statement to read as to post-trial objections. The rules provide me to read as follows. Does either team have serious reason to believe that a material violation of any rule has occurred during this trial? I will remain on the bench for 2 minutes, during which time any protest or objection may be brought to my attention by a team attorney. The team may communicate with all rostered team members, witnesses, bailiff, timekeeper, and advisors, but may not communicate with anyone not appearing on the roster. If no team has any post-trial objections, I will retire for scoring.
The defense has no post-trial objections, Your Honor.
Very well, thank you.
The plaintiff has no post-trial objections and can waive our time.
Very well. I appreciate your civility and professionalism. And at this time, I will retire, so we'll be back as soon as we can. Relax and enjoy yourself. Good job.
Thank you, Your Honor.
You're welcome. Back, good job, congrats once again. We're going to introduce ourselves. Each of the judge will give you a brief introduction, and then they'll offer some suggestions, and then we'll conclude our proceedings. I'm going to start on my far left, and then we'll work our way this way, and then I'll go last. So,
good afternoon, everyone. I want to share the judges' congratulations. My name is Dan Griffith. I'm an attorney with Huntington Bank. I'm the president of the State Bar Association this year, which is why I'm here. I don't get to do a lot of court work. The last time I was in court, I was found not guilty. That's a joke. That's not true. But I was incredibly impressed by the work that you all did today. It was very clear that both teams had done an amazing amount of preparation, which was evident. It's always fun to see how people respond to the curveballs that happen, whether it's a ruling that happens or someone who gives testimony one way or the other. So I thought it was an outstanding event. I thought everyone showed an incredible amount of teamwork, and the poise that we saw today was also really, really outstanding too, and entertaining, which was also really helpful. It was fun to see the witnesses throw some fun things, and we got a little laughs and smiles. But an incredible congratulations to all of you on the great work that you did today. Outstanding performance on everyone's part.
Thanks, Dan. Good afternoon, everyone. My name is Sarah Scow. I am from the Toledo area. I am a partner at the law firm of Spengler Nathanson, where I do trial and appellate work, mostly on the defense side, but occasionally on the plaintiffs. I have been in preliminary injunction hearings, so kudos to all of you. It's a really hard standard because you have to essentially prove the underlying case in the context of trying to have the hard evidentiary burden. So I have been on both sides of seeking that type of relief, and applaud you for thinking through the different aspects of each of the cases related to that difficult burden and standard. I would also be remiss if I didn't mention that I'm currently the president of the Board of Trustees for the Ohio State Bar Foundation, and we're really glad to support programs and partner with OCLRE for things like this exercise, which is really important for the legal profession and the legal system, even if you don't end up becoming attorneys yourself, but you're all showing, even the witnesses in bailiffs today, the importance of the legal system and the rule of law. So thank you for engaging in this exercise academically, but also with a mind toward career exploration. When you're presenting your cases, the importance of themes, the importance of elements, of simplifying cases, but making a number of times you all referred to precedent on both sides effectively, and how to distinguish what happened in one case versus another, to listen to what the opposing party said, to listen to what the opposing attorney said, to pay attention to what your witness is saying, is really important, because you have the point you're going to make,
you have the preparation that you have clearly done, and something goes a little bit differently than you anticipated. So the importance of listening and learning and knowing the rules, which both teams did a really nice job of showing your understanding of these rules, which are complicated, especially in the live context of getting evidence into a record. So theme development can be really important. Analogies can be really important. And analogies can be powerful in both helping to establish your case, but also if you exaggerate a little bit too much, that might not lend credibility to your point as well. But great job by both teams, all of your witnesses, and the council today, and thank you to the bailiffs for keeping things moving as well.
Thank you. I'll go over here.
Good afternoon, everyone. My name is Sarah Welch, the other Sarah. I was, until last week, an attorney at Jones Day up in Cleveland. I am on my way to a new job at the Department of Justice out in Washington, D.C. So at the moment, my profession is mock trial judge. I was in your shoes what I thought was not too long ago until I was realizing on the walkover that some of you were not born when I was in the state championship round a few years back. But I know how much work it takes to get to this point, and I know how much passion it takes from each of you and from each of your parents and coaches and teachers. So I'd like to give a round of applause to all the people who have helped you to get here. Both teams were incredibly well prepared. I know at this point you have lived and breathed this case for the last 3 days at least, most intensely, and for a while before that as well. So incredible preparation. And at this point, when both teams are so exceptional and so well prepared, we're looking at how do you respond to things on the fly? How well are you listening? How canned do you seem on the 11,000th time that you've given this piece of testimony or this opening or closing argument? And how do you respond? How do you improvise when something happens that's a little different from something that you've heard before? So would commend both teams on that. You both made excellent use of the rules during objections. You clearly constructed your examinations with a mind to the elements of the case and with a mind to what was going to be objectionable and what could make it in. I was especially impressed by the smooth transitions back into questioning after objections. We had a number of chances to see that, and each time the witness was paying attention and knew right where they were, and the attorney gave them the chance to jump right back in. So that's that kind of listening and dynamic moving on the fly. One, hobby horse that I always tell people when I judge competitions is that I would always do redirect and recross if you at all have the opportunity to, because that's how you showcase your ability to be dynamic and to respond to what's just happened. And it's another chance to score more points. Why wouldn't you take that second shot? There are times where it just doesn't make sense. I get that. But I would always put a thumb on the scale toward doing those. And it's a chance for your witness to show off their ability to respond on the fly as well. So again, huge congrats to both teams. You've both done an exceptional job. I was on the case committee to help write this case, and it's super fun to see it come to life. So congratulations to everyone.
My name is Caitlin Nesselroth-Johnson. I am a Senior Assistant Attorney General at the Ohio Attorney General's Office. I'm in our Health and Human Services section, where I mostly represent the Ohio Department of Medicaid, the Ohio Department of Children and Youth, and the Ohio Department of Job and Family Services. So I not only do a lot of civil defense, but I also do administrative hearings on behalf of those departments. I am also an alum of this program. Somehow it's been more than 20 years since I competed, which doesn't seem possible. I credit this program with why I am an attorney today, in large part because I'm the only lawyer in my family, so I'm a first-generation lawyer. I was very interested in being a lawyer after my fifth-grade teacher suggested it, probably just because I was assertive and outspoken as a 10-year-old. But I didn't exactly know how to go about doing that, and so I just signed up for my high school's mock trial team, and I absolutely loved it. And I credit a lot of that with why I am specifically a litigator today. How many of you are seniors? Okay, so we do. So we have a few seniors, but we also have some underclassmen. So hopefully the non-seniors will all be coming back to compete again next year. Oh, I also should say, I have had the honor of serving as the Franklin County coordinator for the district and regional levels of this program for the past 10 years now, and I also serve on the competition committee. So if you have any rules-based, things that you would like to see changed, I'm happy to chat with it, always take feedback on those. This was obviously a very, very good trial from both teams. I'm going to point out some things that I liked, and I want to give a little bit of constructive feedback, especially for the underclassmen, but I'll try to do it so it's equal for both teams. I'm really, really strong on themes, hearing themes from both teams. And so plaintiff said, I loved you right out of the gate, elections are not a joke. I think it was one of the first things that you said in opening, and I think it was one of the last things that you said in rebuttal, and I love that bookend of that theme. Defense, I loved when you stood up in opening and said, we beg to differ. I thought that was a really strong opening in the opening statement. I would say I didn't hear the theme as constructively from opening to closing, but what I did hear that I liked was, man, by the time we got to closing, I knew what those three things were in the parody video that were the same. That Denver Saidi had said at the dance that was then also in the parody video. So the mentioning the campaign, saying the wrong name, and then mentioning the bar. Man, you hit those three really hard in the examinations and then echoed it in closing. And it's very hard to work the theme into the examination. So when you can do it, it's very powerful. So really good job in different ways by both teams. I really thought that all four of the attorneys did a good job during direct examination of letting the spotlight stay on the witness. That is really important. That's your job as the direct attorney, and I thought all four of you did a very good job of that. I would say something that I like to see with direct examinations that can be very powerful, it can be very powerful with cross-examination too, is use of transitions. Heard it a little bit. I wouldn't say that I heard it a ton from any of you, but saying like, now I'd like to talk a little bit about, and it cues to the bench where you're going to be going with the examination. So that can be a very powerful tool to use in both direct and cross-examination. I would say I am also, like my colleague, a huge proponent of redirect examination. I didn't specifically notice whether you were close on time, and maybe because there was not a lot of redirect in this trial, and then obviously when there's no redirect, there's no opportunity for recross, but that can be a very, very powerful tool. I would say from both teams, I was a little surprised with the experts that neither of you introduced their CVs. I think I know it's time, and I know time is limited, but it's also just taking 30 seconds to, so can you turn to Exhibit C or can you turn to Exhibit D? Is this your CV? Does it accurately summarize all of your education and your professional experience? Okay, we're going to move that. I know you don't have to move it into evidence, but okay, now we've all seen that it's there. So I was just a little surprised from both teams not to see those used, but if it's a timing thing, I definitely understand that. I thought the witnesses all on cross-examination did a very good job of making concessions when you needed to, but also, man, getting in little barbs that helped your sides. I wrote down a couple of them, like Theo and Ngoma, you said, like, I thought it was the real Denver, like in one of your cross-examination questions, and that's really powerful. And then, like, on the other side, Emery Popovic, like there was one time you said correct, just not in this case. I thought that was also great. I could find examples for all four of you. All four of you did an excellent job with that, because it is definitely a balance on cross-examination of not fighting every single question, but getting those great talking points in when you can. I thought all of you did a very good job. I think that's everything that I wanted to say. But again, this was a great trial, and I look forward to seeing those of you who are not seniors back next year.
Well, thank you to all the judges. This is quite a crew of intellects and a lot of experience who take it to heart. Special thanks again to the parents that are here today and the legal advisors. I say that, I don't need your votes. I have Article 3 protection. So I mean that in a sincere way. It is so delightful. I love a good athletic event. I played sports at Wheelersburg High School, and I love going to those. I love this just as much. I had a daughter that was in music and theater, and all of you are just delightful individuals. The witnesses, the attorneys, but make sure it's still okay to hug your parents and say thank you because of the time and expense that they put into it. Mine still do, and they're old, so it's okay to do that, and it's okay to even write a thank you note if you guys know what those are. They still make stamps, so we like to get those in the mail. But thanks to the parents and to the legal advisors, to all of you, just fantastic. I thought I was sitting in my courtroom in Southern District of Ohio. You were that good. I issued TRO yesterday, and I'm just thinking, did I get all those elements in there yesterday? In the opinion, and irreparable harm, but each of you were just fantastic. Understand this, in the world of mock trial, moot court, it's all subjective. What I like, what the other judges like, it's just different. And take that with a grain of salt. Doesn't mean that it's right or wrong, but it's just subjective. Your wins and losses may rise and fall on the subjective feeling of each of the judges, but each of you were just fantastic. Just some specific comments. In the real world, I love it when there's no recross and no redirect. But here, I tend to believe, if you got that opportunity, it's kind of a double-edged sword. Don't blow it. Don't go up there and ask something outside the scope of direct, because then you're going to get objection. It's going to be sustained. So you have to be cautious. And there's that tendency just to ramble on sometimes. So be careful about that. To the attorneys, you knew the rules frontwards and backwards. I love that. That's a tool that you use. If you go on to be real lawyers, it's a fantastic tool. Local rules are really important as well, but you use those to your best. At one point, I thought I was going to have to put a tip jar up here because there were so many objections. In the 3 federal trials that I've had, there were more objections here than all 3 of those trials, but that's okay. But yeah, I didn't mention I'm Matt McFarland. I'm one of your federal judges. I serve in Cincinnati. Before that, I was on the Court of Appeals in the 4th District, where she is from, which is Southeast Ohio, for 20 years, and then I was a prosecutor and defense attorney. So I've sat in all the seats, and I just love listening to your arguments. It was just a delight to be here, to be part of this program. I didn't have the benefit of this. I was a first-generation lawyer, but my mom, thought I argued a lot, so she thought law school was a good idea. But you all are just fantastic. It's just so wonderful. To our pollster, I wanted to hire you. I was thinking, man, if I was running, I need you on the campaign. And to our parody maker, I needed you. And then to our student, Mr. Latu, I think you could make some pretty good negative attack ads. So those are, and you play those roles so authentically. It was just really a delight. If you participate in this in the future, take these to the grain of salt, because at the end of the day, I think you should be yourself. Whatever you are authentic, that's when you're persuasive. All of you had great eye contact. I don't think one of you took a note up to the podium. It just blew me away with your knowledge and exceptional recall on things. But it was just really, really delightful to be here. I would invite each team, if you are interested in coming to federal court, not by summons or warrant, but I've invited some teams from my neck of the woods, Wheelersburg, Portsmouth West, won the district last year. They came and watched some court hearings in my courtroom. We had a pizza party. And we would invite you. I'm in the Southern District, so our courthouses are in Cincinnati, Dayton, and Columbus. If you're interested whatsoever, please reach out to me. You can get a hold of me on the website. There's access to our chambers. But great job. It was just so fun to be here. Maybe we'll see you in the real world. If I can help you at all in the future, please reach out to me. But congrats to all of you. Yeah, good job. I think that concludes our portion. I think the last thing to do is for them to announce the winning team. So that's not our role. But look forward to seeing you after that's done, and good luck in the future. Thank you.
Thank you.
right, you are watching the 42nd Annual Ohio Mock Trial State Championship. I want to say another congratulations to both of our mock trial finalists on your accomplishments. You should be very proud of yourselves. Before we present the awards, I would like to take a moment to thank OCLRE's sponsors: the Supreme Court of Ohio, the Office of the Ohio Attorney General, the Ohio State Bar Association, the American Civil Liberties Union of Ohio Foundation, and the mock trial competition is made possible in part by a grant from the Ohio State Bar Foundation. All right, at this time, I would like to present the James E. Phillips Outstanding Attorney Award and the Outstanding Witness Awards. The James E. Phillips Outstanding Attorney Award goes to Rachel Greer of Archbishop Hoban. Great job. All right, and now I would like to present the Outstanding Witness Award, which goes to Gabrielle Oboff of Archbishop Hoban. All right, congratulations to both of you. And now, the moment that everyone has been waiting for. After 3 days and 5 trials, the winner of the 2025 Ohio Mock Trial State Championship is Archbishop Hoban. At this time, I would like the advisors of Archbishop Hoban to come up and present each one of their students with their gavels.
So these gavels go to every member of the Hoban Gold team. So congratulations. First, Kate Folk. Her co-counsel on the plaintiff side, Rachel Greer, a junior. Sophia Burgoyne, who portrayed Denver Saidi and Wyatt Latu. Another senior, Gabrielle Bree Abhoff. On the defense team, which made it possible for us to be here, Senior Cassidy Wren. Her co-counsel, another senior, Julia Lee. Our timekeeper, Enza Maltempi. And last but not least, our research assistant and take care of everything, Rebecca Nauman.
Congratulations. At this time, we would now like to invite the state runner-up, Sylvania, Southview, to come up and accept their trophy. Congratulations to our state runner-up.
Thank you. First, on behalf of Hoban and Sylvania Southview, we'd like to thank O'Sillery, Ryan, Jenna, Kate, Judge McBride, Jeff Ginsburg, and so many others that have made this tournament possible. 30 years is pretty tough, but it's a great way to end it for me, to have an opportunity to come in and to play a team as fine as Hoban and for the people there. And I'd like to thank you, even if I borrowed a second of your time there. With that said, the members of my team, we'll start first with our timekeeper bailiff, Jesse Wong. Our Wyatt Latu, Justin Lee. Emery Popovic, which is played by Dia Yerm. And our two counsel, seniors Naomi Bell and of course, David Liu. And I would be remiss if I didn't acknowledge my co-coach, Nicole Hood, and if I could acknowledge one last person, my wife, Vicki Lott. Okay.
All right, congratulations. And this concludes the 42nd Annual Ohio Mock Trial State Championship. Thank you, everyone, for watching, and congratulations again to the teams. Thank you.